Confirm everybody's in ACJ. Thank you.
Okay, thank you. Registrar, you may please call the case.
Morning. I am the Registrar Clerk for this hearing, Acting Chief Justice and Justices of the Constitutional Court or Council are online. I call the matter of Madidimalo, Kislon, Mamadi, and another, and Premier of the Limpopo Province and others for hearing. Council are now invited to place themselves on record. Please note that this hearing is being recorded.
I am Mrs. M.B. Munyamoratu. I'm appearing on behalf of applicants 1 and 2. Thank you.
Thank you, Council.
Thank you very much, ACJ, William Okari. I appear with my juniors, Mr. Makoti and Mr. Malachi, for the first, second, and third respondent.
Thank you, Mr. Mukari.
Good morning, Acting Chief Justice and members of the court. I appear for the 5th and 6th respondents. My surname is Egan.
Thank you very much. Counsel for the applicants, you now have 10 minutes to address us without any interruption. Otherwise, you will be given 45 minutes to address us in full. You may go ahead.
Thank you, Acting Chief Justice and Justices. The application before this court this morning is an application for leave to appeal the whole judgment and orders of the Limpopo High Court of South Africa, handed down on 26 November 2020 by Judge President Makgoba, wherein he dismissed the review application with cost. Acting Chief Justice, before I deal with the application for leave to appeal, there are several condonation applications brought by the parties in this application, 2 brought by the applicants and 1 by the 5th respondent. ACJ, the first condonation is for the filing of the leave to appeal. This application for condonation of leave to appeal was in fact served and filed because the registrar was of the opinion that the application for leave to appeal was late. But Acting Chief Justice, the application was in fact not late, and we have explained in the affidavit that the order of the Supreme Court of Appeal was handed down on 6th May 2021. And in terms of Rule 19.2 of this court, the application for leave to appeal was due on the 27th May 2021. And now this application was served on all the respondents on 25th May 2021. And because of the COVID restrictions, it was emailed to the registrar of this court on 27th May 2021. The only problem here was that the attorney for the applicant mistakenly attached the wrong order from the Supreme Court of Appeal. Acting Chief Justice, that issue was clarified in the affidavit. The third condonation is not opposed by any of the respondents. So this court must just make a finding that the condonation was unnecessary or alternatively grant the third condonation. Now, the second condonation is the condonation for the late filing of the records and written submissions by the applicants. Acting Chief Justice, this also is not opposed. The applicants have explained in the affidavit supporting the condonation application that the applicants were not aware of the directives of this court, which were issued on the 27th October 2021. The applicants have submitted in the affidavit that the applicants only became aware of the directives on the 6th December 2021. This application too is not opposed by any of the respondents. This court already issued further directives allowing the applicants to file 13 copies of the records by 12 January and affording the respondent to file their written submissions on the 2nd February 2022. So we submit that the prejudice which would have been suffered by the respondent had been cured by further directives issued by this court on the 15th December 2021. Therefore, Acting Chief Justice, it is in the interest of justice that this condonation be granted. And now the third condonation, it's condonation of late filing of the fifth respondent's opposing affidavit, which is opposed by the applicant. Acting Chief Justice, I repeat, the application for leave to appeal in this court was served on the respondent on the 25th May 2021. And in terms of Rule 19.4 of the rules of this court, the respondent was supposed to file their opposing documents within 10 days, but 10 days expired on the 8th June 2021. Acting Chief Justice, by the 9th June 2021, none of the respondents have filed their opposing documents or their intention to oppose. But on the 17th of June 2021 and only, that's when the fifth respondent served his opposing documents. So it is common cause that the opposing papers were out of time and it required a substantive application for condonation, which it did not have. So it is also common cause, Justice, that the applicant objected to the filing of these opposing documents without an application for condonation. The objection, Justice, was received by the fifth respondent as early as June 2021. And the fifth respondent, they did nothing. Just 7 months later, when the records and the written heads of argument were already filed, the fifth respondent now served and filed the application for condonation. Acting Chief Justice, it is not explained in the supporting affidavit for condonation as to what took the fifth respondent more than 7 months to file the application for condonation. Only that the respondent, they are of the view that the delay is only 5 days and therefore it is minimal. It is our submission, Acting Chief Justice, that it is not correct. That cannot be correct. The applicant in the application for condonation must also explain the delay in lodging the condonation application itself. But what we find in the affidavit is that the respondent did not file the answering affidavit on time because he thought the application for leave to appeal was in terms of Rule 19 of the rules of the court. And that cannot be correct also because the notice of motion was very clear from the heading that the application was in terms of Rule 19 of the rules of this court. Justice, even if for a moment the court accepts the explanation given, the problem is that the respondent did not explain the delay or for filing the condonation. The delay of 2 months is too long. Worse when there is no explanation provided. Another problem with this application, Justice, is that the application filed when already the applicants have filed their written submissions. We submit that if the application is granted, we will be prejudiced because when the written submissions were made, we treated the application for leave to appeal as unopposed. So we will be prejudiced. And now the fifth respondent is putting the blame on applicants and the registrar of this court. He's blaming the registrar for not acknowledging receipt of his answering affidavit. And he also blames the applicants for not objecting to the late filing of this answering affidavit. Acting Chief Justice, we submit that it is the responsibility of the attorney to ensure that the registrar received papers. If you do not receive a message to the effect that your papers were received, you must make a follow-up. You cannot wait for more than 7 months. Thereafter, you blame the registrar and your opponents. Justice, the fifth respondent in his supporting affidavit for condonation went to the extent of being dishonest under oath. He stated under oath that the applicants did not object to the late filing of the answering affidavit. When provided with proof that we objected, he now changed his tune to say it was oversight on his part. It can never be oversight. It is pure lie under oath and an attack on the officer of the law. Justice, we pray that this application for condonation be dismissed and the fifth respondent be ordered to pay cost of this application on attorney and client for unwarranted attack on the officer of the law. Now, as for the first to the third respondents, which is the Premier, the MEC, the Commission of the Limpopo House of Traditional Leaders, there are no opposing documents served or filed. But we've just noted in their written submission that they mentioned that the application for leave to appeal is opposed. But it is not true. They failed to serve and filed their opposing document. And just this morning, I'm advised by my attorney that he noticed a document on the link purporting to be the opposing document. And we have not received such document. And when we look at that document also, there are two things there. It is out of time and it is also served to the wrong attorney. And it cannot be accepted. And that concludes my submission on the condonation. I'm now going to proceed to the application for leave to appeal. Our first submission.
You have exhausted your 10 minutes, but seeing that you spent it on condemnations, I'll give you 5 minutes to address us on the substantive issues without interruption. Only 5 minutes.
Thank you, Acting Chief Justice. Our first submission is that the application for leave to oppose, the leave to appeal, it remains unopposed for the very explanation that I made during my condonation submissions, and it must be decided on the papers of the applicants only. Acting Chief Justice, the first issue that we will deal with is the issue of jurisdiction of this court to hear the application. Justice, we have already dealt with this point in our written submission. The question whether a review court sitting in terms of Rule 53 of the Uniform Rules of the High Court may exercise the power it has in terms of Rule 65 to dismiss review application because there are dispute of facts on affidavit. It raises constitutional issues alone. It implicates the right of access to court, which in the context of civil proceedings is often referred to as the right to a fair trial. That this court has jurisdiction, it is very clear. Thus, it is in the interest of justice that leave to appeal be granted. Justice, in the recent case of Langa versus Premier of Limpopo and others of 2021, ZACC 38, this court said the following about jurisdiction and leave to appeal. I refer the court to paragraph 37, but I'm going to read it. This matter concerns the lawfulness of the Premier's recognition of the 5th respondent as senior traditional leader and removal of the applicant as senior traditional leader pursuant to the provisions of Framework Act and Limpopo Act. And this matter, it implicates Section 211 of the Constitution to the extent that it concerns the institution of traditional leadership, which this court has said has important constitutional dimension. The appeal thus engages the constitutional jurisdiction. Leave to appeal should be granted on the basis that the application implicates a matter of considerable importance to the Mampela traditional community and has strong prospect of success, and as will become evident, I close quote. Acting Chief Justice, with regard to jurisdiction, this court has jurisdiction in this matter for the same reason upon which this court relied in Sikla 1 to support its conclusion, and it had constitution in respect of the matter and the matter of Langa that I've just quoted. And in this case, this court also has jurisdiction because the matter raises arguable points of law of general importance, which ought to be considered by this court. And that point is, what steps was the Premier required to follow when he received the resolution from the Mamadi royal family for the recognition of senior traditional leader in terms of Section 12 of the Limpopo Traditional Leadership and Institution Act 6 of 2005 as amended? It is also in the interest of justice that this application for leave to appeal be granted. This matter is very important in the Mamadi community because it deals with the traditional leadership of the entire community. We therefore pray that the application for leave to appeal be granted. Now I tend to deal with the prospect of success, Acting Chief Justice, and the merits of this appeal. The court dismissed the review application on the basis that there were dispute of facts on papers and resolved the dispute of facts by applying Plascon even rule, but incorrectly, and decided the matter on the version of the respondents, ignoring admitted facts by the respondents. In this oral submission, Justice, I will demonstrate how the court erred in its judgment of the case. Firstly, the High Court erred by blaming the applicant for the—
Your 5 minutes is gone. You may proceed, but now you may be interrupted by my colleagues with questions. You may proceed.
Thank you, ACJ. Let me just begin. Firstly, the High Court erred by blaming the applicants for bringing review application by way of motion in terms of Rule 53. In a review application, the Rule 53 record, it plays a very vital role in resolving the dispute between the parties. This court, Acting Chief Justice in Helen Suzman Foundation versus Judicial Service Commission of 2018, ZACC 8, said the following, I quote, "The purpose of Rule 53 is to facilitate and regulate application for review. The requirement in Rule 53(1)(b) that the decision maker file the record of decision is primarily intended to operate in favor of the applicant and in review proceedings. It helps ensure that review proceedings are not launched in the dark. The record enables the applicant and the court fully and properly to assess the lawfulness of the decision-making process. It allows the applicant to interrogate the decision and, if necessary, to amend its notice of motion and supplement its ground for review." And paragraph 14, "Our courts have recognized that Rule 53 plays a vital role, enabling courts to perform its constitutionally entrenched review function. Without the record, a court cannot perform its constitutionally entrenched review function, with the result that the litigant's right in terms of Section 34 of the Constitution to have a justiciable dispute decided in a fair public hearing before a court with all issues being ventilated would be infringed." And paragraph 15, "The filing of the full record furthers an applicant's right of access to court by ensuring both that the court has relevant information before it and that there is equality of arms between the person challenging the decision and the decision maker." So equality of arms requires that parties to the review proceeding must each have reasonable opportunity of presenting.
Ms. Munyamuratu, can I just ask a question? I hear you say and you make this point in your head well, that initially you had to proceed in terms of Rule 53. Am I right? When it transpired that there were disputes of fact early on the stage, the pleadings stage or the review proceedings, was it open to you to refer or to ask the court to refer the matter for trial for oral evidence?
Thank you, Justice. It only transpired during the hearing that there are dispute of facts. It transpired when Judge President accepted the defective affidavits, and then he said there are dispute of facts, but counsel did not concede to that. He requested that if the court is of the view that there are dispute of facts, material dispute of facts, the court may refer the application, the matter to oral evidence. Yes. Thank you, Justice.
Well, what is the meaning and significance of the opening words in Rule 53(1), which say, "save where any law otherwise provides"?
It means where you cannot disadvantage yourself. It means where you can. Repeat the question again, Acting Chief Justice.
Your stance, as I understand it, is that you did not, or the applicants did not have any option but to bring the review by way of motion proceedings in terms of Rule 53. Is that correct?
Yes, that is correct.
I asked the question, what is the meaning of the opening words in Rule 53(1), which say, "save where any law otherwise provides"? In other words, Rule 53 says, "save where any law otherwise provides, all proceedings to bring under review the decision or proceedings of any inferior court or of any tribunal, blah, 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 blah.
Okay, thank you, Acting Chief Justice. It means if there's any law that we can bring the application, that is we can bring the application with. But in terms of review proceedings, it says all proceedings must be brought by way of Rule 53 application. And in this case, there is no other way. There is no other law that says.
Well, the part of Rule 53 that comes after the words save where any law otherwise provides tells us what should happen if you wish to bring review proceedings, isn't it?
Yes.
But save where any law otherwise provides must be saying there are other situations where you can do it differently, isn't it? As long as there is a law that provides otherwise.
Yes.
You agree?
I agree.
Now, is there no law, bearing in mind that I would imagine law may be statute, maybe rules, I'm not sure, regulations and case law. Is there no law that says if there are to be disputes of facts, you must institute proceedings by way of action?
Acting Justice, there is, but then if the dispute of facts are foreseeable from the beginning, but if you bring it by way of Rule 53 and not action, still you cannot be punished, because the reason why we brought it by Rule 53 application is because we wanted the benefit of the Rule 53 record. Otherwise, we would bring it in the dark. And because we brought it by way of Rule 53, it doesn't mean we can be punished. And those dispute of facts, we have denied them in our papers. There were no serious dispute of facts, and we opted for Rule 53 for the very benefit of getting a Rule 53 record so that we do not launch the application in the dark. That's our submission.
Well, let's start where we should start. Do you accept that there are material disputes of fact that arise in this matter?
I do not accept.
You do not accept that?
We have mentioned that in our supplementary affidavit of yes, that there are no material dispute of facts.
Yes. So if this court were to conclude that there are material disputes of fact, what would that do to your case? I accept that you are saying your position is that there are no disputes of fact.
If the court is of the view that there are a material dispute of fact, I will advise the court to look at the common causes in this case, because there are admitted facts in our affidavit, in the applicant's affidavit.
Well, when you talk about disputes of fact in this context, you have to talk about material disputes of fact, and then that would mean disputes of fact that would make it impossible to resolve the dispute without resolving them.
But Acting Chief Justice, there are also legal points that we brought the review application on, that the matter can be resolved on legal points. It's not only on material facts.
Yes. Okay, proceed.
CCJ, I wonder if I could just ask.
I'm sorry, Justice Ontaralta.
I wonder if I could just ask a very quick follow-up question.
Yes.
At least since Forbes versus the Jockey Club, I think our law has been clear that Rule 53 may be useful to an applicant, but is not obligatory for the purpose of bringing a review. So I'm wondering why you are suggesting that it is peremptory to bring a review under Rule 53. That's not the state of the law as I say, at least since Forbes versus the Jockey Club.
Okay. May I refer the court to the case of Supreme Court of Appeal in the National Director of Public Prosecution versus Zuma, case number 57308. I want to make my point, but let me just start by quoting this. It says, motion proceedings, unless consent with interim relief, are all about the resolution of legal issues based on common cause facts. Unless the circumstances are special, they cannot be used to resolve factual issues because they are not designed to determine.
I'm sorry to interrupt you.
Yes.
Sorry to interrupt you, but I'm very interested in your answer to Justice Unterhalter's question. And perhaps I can assist by just rephrasing it slightly.
Okay.
And isn't this actually where you should be starting with your case? The question of whether Rule 4053 is peremptory or not, whether the applicants were obliged to follow Rule 53, or there were other procedures that they could adopt. Isn't that where your case must start? And I believe the acting Chief Justice was alluding to the same issue.
Okay. Okay. For us, it was the only way to go in terms of Rule 53 because we needed the record. So we're not saying there are no other legal provisions, but we are saying for us, it was the only way for us to resolve this matter.
Isn't that
Hang on. Justice Unterhalter, proceed, because I think your question needs to be answered definitively.
So,
yes.
As I understand your case, it's not that you had to use Rule 53, but that because Rule 53 has particular advantages for an applicant, you wished to do so, and you don't want to be punished for having enjoyed the procedural advantages of Rule 53. Isn't that what you're saying? That's
exactly what I'm saying, Justice. Thank you very much.
Yes, thank you.
Well, I must ask this question. You just said for you, the Rule 53 was the only way. At least that is what I understood you to be saying. In what respect then were you saying Rule 53 was the only way?
If we had not used Rule 53, the applicants would have forfeited the benefits of Rule 53 record, and the court was not going to be able to perform its constitutionally entrenched review function, with the result that the applicants' right in terms of Section 34 of the Constitution to have a justiciable dispute decided in a fair public hearing before a court with all issues being ventilated would be infringed. So for us, it was a benefit.
What do you say to Justice Unterhalter's proposition to you that since Forbes' case, it's the law is that you are not bound to Rule 53 in all cases for purposes of reviews? Do you accept that proposition, or do you not accept? If you don't accept, would you like to address it so that he knows what you have to say?
No, I accept. That's why I said that is my point exactly. But you cannot be penalized where you have used it. You cannot disadvantage yourself by using Rule 53 application.
So are you saying, therefore, that even if before you commence proceedings or review proceedings, you are fully aware that there are material disputes of fact between the parties, it is fine for you to use Rule 43, even though you accept that it is open to you to bring a review by way of action? Is that what you are saying?
What I'm saying, Acting Chief Justice, is that if we were aware of a material dispute of facts from the onset, we were not going to opt for it. But then in this case, there are no material dispute of facts that we were aware of from the beginning. And there were also, it's because there were admitted facts in the applicant's affidavit.
Okay, all right. So if I understand you correctly, what you are saying is you accept that if a party is aware of material disputes of fact that will arise in a review application, if in a review application, you accept that in that case, such an applicant should explore other ways of bringing the proceedings other than motion proceedings. But you are saying that in your case, the applicants were not aware of such disputes, and therefore they should not be criticized for having used Rule 53. And your submission is that the disputes of fact, if they did arise, arose later, and then at that stage, what the court should have done is to refer the matter to oral evidence and not to have dismissed it. Have I captured your position correctly?
Very well, Acting Chief Justice, thank you. That is
okay,
correct.
all right. You may proceed then.
Can I follow up, ACJ?
Yes.
When the respondents raised the issue of a different genealogy, did that not raise a material dispute of fact?
Thank you, Justice. We have clarified that in our reply, supplementary reply affidavit. And because we have clarified that, we believe that they were no longer.
Yes, you clarified it. That was your version. But their version was that there is a different genealogy that is different from yours. Was that not a material dispute of fact? And going back to my question that I asked you, yes, when you then launched the proceedings, you thought that Rule 53 would be beneficial to you. But when it then became apparent that there was a dispute, why did the applicant not ask to refer the matter for oral evidence?
Okay, now, if I hear you correctly, Justice, you want to know that when we realized that there was a difference in the dispute of facts in the genealogy, what did we do?
Yes.
Okay, there was no difference. There was no difference in the genealogy. The only dispute in the genealogy is that the two genealogies, the fifth respondent have begun the genealogies with many chips before the Hoshi Mamadi, and that's where the difference was.
But those genealogies, were they the same?
They were not the same.
Yes, did that not amount to a dispute of fact?
Just a moment. Can I just make this submission that on the 25th October, the judge president of the High Court indicated to the counsel of the applicants that there were dispute of facts on the papers before the court, and the counsel replied by saying, if the court is of the view that there are real dispute of facts, which is material dispute of facts, the court should refer the matter to oral evidence, because we were not of the view.
I'm sorry to interrupt you, Ms. Munyamuratu.
Munyamuratu, please.
Yes, I was just following up on your responses to my colleagues and your initial questions. You said that you chose the Rule 53 route because of this, because you needed to get the record and all of that. And saying once the respondent filed their pleadings, it became apparent very early on, even before the intervention of the judge president, that the pleadings of the respondents were raising a dispute of fact. And I was simply asking, why did you not at that stage ask for the matter to be referred for oral evidence? I've asked the genealogy. Also, it became apparent early on that there was a dispute about the constitution of the second applicant and whether they are indeed members of the royal family.
Okay. In the first, I hear you. In the first answering affidavit, there were no dispute of facts. The answering affidavit from the 5th respondents, there were no dispute of facts. And then the affidavits that were filed, those are the affidavits that we raised, that they were not according to the regulations of affidavits. And we requested the court not to admit those affidavits. And the dispute of facts only transpired from those affidavits that we requested the court not to admit.
Excuse me, Ms. Munyamurat, if my sister Chikri has finished, I need to put a question to you. My sister, are you done?
Justice Chikri, are you finished with your questions?
Yes, yes.
Thank you. Thank you. Justice Matopo.
Ms. Munyamurat, before a party launches motion proceedings, a party has to make a determination. You tell me if I'm correct. Right at the time when the proceedings are launched, whether there is or there will be a foreseeable dispute of fact. If a party, regardless, and that talks to the background of the issue that you want the court to ventilate. If prior to setting up your affidavits and everything else, you are aware that there could be problems, i.e. disputes insofar as the issue that you want the court to adjudicate upon, and you choose to proceed by way of motion proceedings, one would say you foresaw that there would be such disputes, and regardless, you chose motion proceedings. So that is how disputes of facts are resolved, number one. Number two, the submission that you make is that the dispute of facts only emerged once JP Makgoba admitted that uncommissioned affidavit somewhere on the 25th of October 2020, thereabouts, right? My sister Chikri put to you that right at the beginning, the issue of the genealogy was a sore point. When you launched the papers, that was a live and palpable issue that you, the applicant, should have foreseen that would play itself in court, right? The last point is, at the hearing, your predecessor conceded that there were material disputes of fact. And this is found in paragraph 31 of the judgment of Makgoba JP. So you would contend that the dispute only emerged after Makgoba brought that to your attention. That cannot be correct. So I wish you to address those three propositions that I've put to you.
Okay. Thank you, Justice. I want to make this submission, and I have made it already. Firstly, that the council did not concede to the dispute of facts. I have also read the papers, including the supplementary heads of argument filed with the court on the issue of dispute of facts. All I see is not an admission of a dispute of facts. Acting Chief Justice and Justices, on 25th October 2021, the Judge President of the High Court indicated to the counsel of the applicant that there are dispute of facts on the papers. And that was the time when that matter of dispute of facts was emerging. And that the counsel replied by saying that if the court is of the view that there are real dispute of facts, the court should refer the matter to oral evidence. Sorry for my tongue, to oral evidence. And the counsel then referred the court to complementary on Erasmus regarding Rule 53 application. And this is not an admission by counsel. And again, I want to mention that the dispute of facts were not foreseeable in the beginning. We also needed the records to guide us to understand the issues from the records. That's my submission.
Can I just quickly follow up and just put this to bed? Why didn't you consider, if you had proceeded on motion, that the machinery in the rules of provided for in Rule 35 would have come to your aid?
Rule 35 is only discovery. You discover only the documents that are relevant to the proceedings. It's not all the record, because we needed all the records. So you'll be disadvantaging yourself if you go with a Rule 35. Rule 35 and Rule 53, they are different. They're very much different. You are limiting yourself. You'll be limited by way of doing it.
Sorry, can I?
Chief Justice, if I may. Ms. Munyamarato, I think we must start at the basics and what the law says. I would like you to forget for a minute what the applicant's case is. Let's just see if we can establish what the law says. Is an applicant prohibited from bringing, this is in terms of our law, in terms of our jurisprudence, is an applicant prohibited from bringing review by way of notice of motion where there are foreseeable disputes of fact?
No, the applicant is not prohibited, Justice.
And on what authority do you rely for that submission?
The applicant is not prohibited for reason being, if the applicant needs to get the record, the Rule 53 record, he has the right to do that. And it is only by way of Rule 53 application that you can get the record. And the applicant cannot be punished for that.
So if that is the law and that is our jurisprudence, can the applicant then be punished for bringing review proceedings by way of notice of motion?
No, the applicant cannot be punished for that.
If during the course of the proceedings, it becomes clear that there are material disputes of fact, how should that be resolved?
You ask for oral evidence, to lead oral evidence for an oral trial, yes. And we did that for that matter, but we were refused.
Now, in your submissions, you mentioned that there were issues that needed to be decided in respect of which there was no dispute of fact. What are those issues?
Those are legal points of law. Let me just go take the quote to them. They are in my head, but let me just get them. We are saying our submission is that the problem with the judgment of Judge President is that he did not consider in his judgment legal issues raised in the review application.
Ms. Munyamarato, can you list what the issues were in respect of which there were no disputes of fact? Either factual issues or legal issues which you say could have been determined by the High Court.
Okay, the first point, the Babiroba Mamadi community is a traditional community recognized as such by the Limpopo provincial government. The first person of importance is Hoshi Mamadi Madidimalo Mamadi. He was a chief by virtue of his birth, and he married his candle wife or principal wife in DA, and was blessed with 2 sons, namely Mpefu and Mapula. Rampefu was the oldest son and heir to the chieftain.
Ms. Monyamarato,
Yes.
can you please list the issues? Can you itemize the issues that you say the High Court could have decided the matter on the papers?
It
Can you
is
just
this common.
list the issues, please.
They're in my head, but I'm going through them now.
Okay, Ms. Monyamarato.
Paragraph 26 of my head. It's on paragraph 26 of my head. Those are the common cause facts. Paragraph 26 of my head. As I go through them.
Justice Theron, would you like her to go through them?
I have asked a question, Acting Chief Justice, and I would like my question to be answered if that's possible, please.
Yes. Okay. Go ahead, counsel.
Okay, can I go through them? Okay.
Well, I think you must go through them if that's that provides the answer as you see it.
Okay. These are common facts which we are saying the court could have considered and their legal point. So we're saying
Ms. Monyamarato, if I may assist you. In paragraph 26 of your heads of argument, are you with me, Ms. Monyamarato?
Yes.
In paragraph 26 of your heads of argument, you list the facts that are common cause between the parties. Is that right?
Yes.
And these common cause facts go from page 15 of your heads of argument to the middle of page 20 of your heads of argument.
Yes.
Now, if you read those common cause facts to us, they don't answer my question. My question was, what were the issues that could have been decided by the High Court, either based on the common...
Those are the legal issues, Justice.
I haven't finished my question yet.
Right,
I was waiting for you to complete taking instructions because I assumed that is what you were doing.
Yes. Okay, let me just get the instruction from the attorney.
Well, I'm wondering whether that's an issue which requires instructions, isn't it? Because the question has to be answered based on the papers, on what's in the papers, isn't it?
Yes.
Taking instructions is not going to help you with that, will it?
It's section 15. The legal issues is section 15 of the Traditional Leadership Act, and also section 12 of the appointment, which is the appointment. These are the legal issues.
Counsel, I'm sorry. It might help you answer Justice Theron's question if you, for a moment, reflect on what the dispute was that you wanted the court to resolve and what the issues were that the court would have to resolve in order to resolve the dispute, the difference between the dispute and the issues. So just remember what the dispute was that you wanted the court to resolve and what the issues were that the court had to resolve in order to resolve the dispute. It will help you, it will probably help you to answer her question.
Okay. The first one was to review and set aside the decision of the Premier that was taken on the 1st June 2018. Section 12 of the Limpopo Act, which mirrors Section 11 of the Framework Act, regulates the recognition of the senior traditional leaders by the Premier. So now it says, whenever a position of a senior traditional leader, headman or headman is filled, the royal family consent must within a reasonable time.
May I assist you, please?
Yes.
The way I read the papers, I understand that the legal issues which the applicant is saying, and please correct me if I'm wrong.
Yes.
Which the applicant is saying the High Court could have answered related to Section 30 of the Limpopo Act and Section 25(4)(b) of the Framework Act. The relief which the applicant was seeking related to Section 12 of the Traditional Leadership Act.
That is correct.
That is not the dispute or the legal issue that could have been resolved without the referral for oral evidence. So we're not talking about Section 12. That's if I understand your papers, but maybe you understand it better than I do. And you'll correct me if I'm wrong. But as I understand the papers, the applicant is saying the two legal issues which the High Court could have resolved was related to Section 30 of the Limpopo Act and Section 25(4)(b) of the Framework Act. And the High Court erred in not resolving those issues.
That is correct, Justice. That is very much correct.
Where does that answer leave you, Justice Theron? Is it complete? Is there more that you still want from her?
Thank you, Acting Chief Justice. I think for now it might be best for Ms. Manyarata if I leave her to proceed to present her case, Acting Chief Justice. Thank you.
Okay, all right. I just mentioned that we are at 8 minutes to 11. She has gone beyond her 45 minutes. But it may be that there are other colleagues who do have questions. So just proceed, Ms. Counsel, and then I'll give you a little bit of time and see whether colleagues have questions. But if they don't have questions, I'll stop you in a few minutes.
Okay. Thank you, Acting Chief Justice. As I have mentioned in my papers that the matter was supposed to have resolved on the points of law. And it cannot be correct, Justice, that the court dismisses the application due to dispute of facts while there are arguable points of law which the review application was based on. And this court is approached by the applicants in order to resolve this matter on these arguable points of law. And we have already dealt with these points in our written submission. And in this oral submission, I'll just say, we want to stand by our submission as our written submission, Acting Chief Justice, as much as the time is already gone. Thank you, Acting Chief Justice.
Thank you.
Ms. Manyarata, excuse me, ma'am. If we are with you on the legal points, the ones where you say the High Court should have dealt with them, the one being the mandate of the Commission, that its period had expired when it submitted the report, and the second one being the failure of the Premier to seek advice from the House of Traditional Leaders. If we are with you that the High Court did not deal with these 2 points, what would be the remedy? What are we supposed to do as this court?
Okay. I think this court would have to deal with these legal issues and see whether the court was correct to decide the matter in the way it did and correct it for us.
No, remember, the High Court did not deal with the 2 issues at all. Why should we decide them if the High Court, should we not remit the matter to the High Court to deal with the matter if we are with you on those 2 points?
Justice, the the judge president have dealt with the merits of the matter. If we can check in the judgment of judge president, I think it's in the last page. His judgment is based on the version of the respondent, which means he has dealt with the merits of the case. So the case has been dealt with already.
Let's forget for the moment, not say anything about the merits, because the merits, remember, we have the issue of the factual disputes that are there. There are 2 points that you say are legal points. One is the authority of the commission. You are saying the report was submitted long after its period had expired. And you say the High Court did not say a word about that issue. That's the first one. The second one is the Premier at the least should have, in terms of Section 30, should have gone, approached the House of Traditional Leaders to seek advice. The Premier did not do that. Maybe that one may be linked to the merits, but the first point is a standalone point. Now I want to know from you, what should we do? Can we, as this court, decide that point when the High Court had not dealt with it?
Thank you, Justice. I think it will be a best remedy for us for the Constitutional Court to refer the matter back to the High Court so that the High Court can deal with these legal points that were raised, these legal issues. I think it will be best for this matter. It will do justice, in fact, for this matter. Thank you.
Thank you. Sorry, my sister's done. Acting Chief Justice, through you.
Yes.
Ms. Manyamarato, the legal points that you advance, it does appear that they don't stand alone exclusively as legal points, because in respect of both those points, the first one is the authority and the lifespan of the commission. There appears to be a dispute on the papers whether that was in fact lawfully extended. And if it was lawfully extended, then that legal issue is mired in a factual dispute and you can't insulate it. The second one, equally so, because as I understand it, Section 12 would only create an obligation on the part of a Premier to do the things that Section 12 says that the Premier must do if the royal family concerned makes a certain recommendation. But here again on the papers, there's a very dispute as to who the royal family is, and there's sort of two versions of the royal family. So does that not lead to the conclusion that even the points of law can't be determined without looking at the facts? And if the facts themselves are in dispute, it doesn't really matter. And the argument that the case can be resolved in the points of law is certainly not a sustainable one. What do you say to that?
I'm saying, okay, in terms of the commission, we do have a document that says the commission was supposed to finish on in 31st December 2015. And there was a hearing that was held in 2013. And the applicants, they've never received a report on the findings of such hearing. And now they came after when the term has ended. And that in terms of the law, they were supposed to have finished within their time frame. There's no any evidence that term was extended. And now on the second one, the issue of dispute regarding the royal family, it is raised by the said Napi Solomon Inchabeleng in the affidavit of on behalf of the Premier. And we have raised this issue in the High Court to say the deponent of that affidavit is also not authorized because there are no even confirmatory affidavit in supporting to that. And the deponent is not even a member of the Mamadi royal family. So he's the one who's challenging that. Whereas the fifth respondent have admitted that the first respondent was the senior Mukhoma and the structure of the royal family. So those dispute of facts, they are misplaced, Justice.
Can I ask you, counsel? I tried to look, and I may have missed it. I tried to look in the applicant's founding affidavit in the High Court for the place where the applicants take the point about 5 years and the commission and its term having expired. I couldn't find it, but I may have missed it. Can we find it in the founding affidavit?
No, Acting Chief Justice, it's in fact in the supplementary affidavit. It's
Even in the supplementary affidavit, I tried, but I may have missed it. Do you want to tell us what paragraph, and could you read it?
Yes, let me just get it here. Is it in? Okay, it's in volume 2 of 5, page 166. Let's see. Yes. I'm going to read it. It says, I am advised, which advice I accept, that in terms of the provision of section 25(4)(a) and B of the Traditional Leadership and Governance Framework Amendment Act 23 of 2009, report of the Khatla stands to be reviewed and set aside because it was not conducted in line with the provisions of section 25 of the Act. In terms of section 25(4)(a) of the Act 23 of 2009, the Commission may only investigate and make recommendation on those disputes and claims that were before the Commission on the date of coming into operation of this chapter. And section 25(4)(b) provides that the Commission must complete the matters contemplated in paragraph A within the period of 5 years, which period commences on the date of the appointment of the members of the Commission in terms of section 23 and or any such period as the Minister may determine. Yes.
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 Okay. Thank you. And yes. You want to continue?
Okay, I just also wanted to point out there, down on paragraph 17.5, there's a letter there. It says, it is also common cause that the commission that investigated our matter was established in January 2011, and its term of office expired in December 2015. And then there's an attachment from the commission on page 9 of the paginated annexures MKMS1.
Yes.
Yes.
Yes. Now, if the commission, let's assume that either this court or the High Court were to conclude that the commission acted ultra vires in dealing with the dispute after the expiry of the period, would that not lead to this situation? Namely, that because such commission is the forum that is established to resolve these types of disputes, and there are disputes of fact about who is entitled to take the position, would it not lead to the position that the dispute must be referred afresh to either that commission, if it still exists, or a new commission should be established to resolve that dispute? In other words, would it be appropriate for either this court or the High Court to try and resolve that dispute?
Okay, Acting Chief Justice, we are of the view that it's our submission that the commission acted ultra vires, and it was our prayer, it is our prayer that the findings be declared null and void and alternatively reviewed and set aside. And if it happens that way, I think maybe the matter should be shelved and be referred to a new commission for resolution. That will be much better. But going with these findings, it will be prejudice to the applicant.
Yes. Yes. Okay, all right. Yes, Justice Theron.
Thank you, Acting Chief Justice. Ms. Monyemorato, the issue about whether the Premier acted ultra vires section 12 of the Limpopo Act by refusing the second applicant's request that the first applicant be appointed as traditional leader. Is that issue before this court?
It is before this court, yes.
Why do you say that, Ms. Munyamurato? Where is that decision challenged?
We are challenging the acting justice that the acting Hoshi has been appointed in terms of section 15, but now we see in the papers they're saying he is acting. Yes.
Let's leave the acting appointment for aside.
Okay.
Can you show us where did the applicants challenge the decision not to appoint the first applicant as traditional leader in the High Court? Where was that challenged in the High Court?
Okay, it's in the letter. It's to refuse the acting, not because there are two. We're talking of two resolutions. The royal family submitted the first resolution requesting
Ms. Munyamurato, let's take it slowly.
Yes.
The applicants did not challenge the decision not to appoint the first applicant as traditional leader in the High Court.
The applicant did not challenge the applicant. Can you please rephrase? The applicant did not challenge the applicant. I did not get that, Justice.
The applicants did not challenge the decision not to appoint the first applicant as traditional leader in the High Court.
We have challenged the acting because the decision not to appoint in terms of section 12 is not the correct one. The royal family resolution was to appoint in terms of section 15 for acting. That's what the applicants
so do you agree that the applicants did not challenge the decision not to appoint the first applicant as traditional leader in the High Court?
That is correct.
They challenged the decision about the acting appointment.
That is correct, Justice.
So that issue is also not before this court.
It is before this court, Justice.
Okay.
I think that Justice Ron is referring, and she'll tell me if I misunderstood, she's referring to your failure to challenge the appointment as opposed to any challenge to an acting appointment. Am I correct, Justice Ron?
That's correct, Acting Chief Justice. Thank you.
Yes, and maybe the question is if you don't challenge the actual appointment, what's the point of challenging the acting appointment?
Okay. Acting Justice, Chief Justice, we've made it very clear in our application that the first purpose of our application was that the decision of the Premier taken on the 1st June 2018 not to recognize the identification of the first applicant as acting traditional leader be reviewed and set aside. So we're challenging the acting part of it. And it is before this court, Acting Chief Justice.
Justice Theron?
Thank you, Acting Chief Justice.
Okay, all right.
CCJ, may I raise something, please, with Ms. Munyamurato?
Yes.
One of the contentions you make, Ms. Munyamurato, in challenging the Commission's recommendations to have it set aside is that the Commission is not empowered in law to proceed with an inquiry once there's litigation pending. Do you persist with that contention?
Yes, I still do, Justice.
On what basis can that be right, Ms. Munyamurato? Because it seems to me that commissions would forever be hamstrung then in not being able to proceed where even frivolous or vexatious litigation is launched, which happens quite frequently in the course of commissions. Is there any authority for that proposition in our law? Can you cite any case? Because I couldn't find any in your heads.
No, we have also made it submitted in our written submission. What we are saying is that already by the time when the matter was referred to court in 2016, the term of the commission had expired, had ended.
Sorry,
And
that is another issue. All I'm asking is, can you cite a case where a commission was forced to terminate its proceedings or to interrupt its proceedings because of litigation that was instituted?
In circumstances where there is no interdict.
Correct. Yeah, where there's no interdict. Thank you, ACJ.
No, I do not have that 18.
Yeah, but that's why I asked, do you persist with that contention?
Okay. No, okay, I will withdraw it for now. Okay.
Thank you, ACJ.
Well, for now is forever. Counsel.
Excuse me, ACJ, ma'am.
Yes, Justice Matopo.
Ms. Munyamarato, if the two legal points that you mentioned, that is the section 30 and the 25.4, are decided in your favor, on the questions put to you by my sister Mhlanhla, you said the proper course would be for this court to remit the matter to the High Court. Did I hear you correctly?
He's saying if the court is of the view of remitting it back to the High.
No, I'm asking you if the two legal issues that you alluded to are decided in your favor.
By the High Court.
Yeah, by us. The High Court, we're not there yet. We are before us now.
Yes.
And if we agree that the submission that you made have merit, on questions put to you by my sister Mhlanhla, you said the proper course would be to remit the matter to the High Court. I just want to understand if I heard you correctly on that submission.
Justice, I didn't hear that. There was some interruption. Can you just
I will
repeat that for me? Yes.
I said on the two legal issues that you identified, the section 30 as well as the section 25.4, right? If those two issues, we've decided the case today in your favor, you said on questions put to you by my sister Mhlanhla that the proper approach would be to remit the matter to the High Court to deal with it. Did I understand you correctly?
Justice, I'm experiencing network problems. You keep on breaking in between, so I did not hear you in full.
I will repeat.
I don't know whether.
I will repeat. No, it's not for the last, for until you hear me.
Because I'm struggling. You keep on breaking in between.
No, don't worry. These things do happen. Don't worry. I'm saying the two legal issues that you indicated could have been decided by the High Court apart from the disputes of fact. If they are decided in your favor, or if we find your submissions to have merit, and you said we could or we should refer the matter to the High Court, we should remit. I just want to know if I understood you correctly in that submission.
I'm saying either the Constitutional Court can deal with these matters, with these issues, as the first court, the court of first instance, and also the last, or can remit it back to the High Court.
Okay, if we remit to the High Court, right? Because Justice Makoba did not deal with those issues, right? The parties will go back to the High Court and fight it out there. Am I correct?
Yes, Justice.
If you lose before us now, and the matter up there, your appeal is dismissed, you still have the last dance before the High Court. Am I correct? what would be your impediment?
If
You would
it's
have been.
dismissed-
Yeah, I just want to know. That's where I want to debate this issue with you. Will you want to take instructions?
No. I'm listening to you, Justice.
Will a plea of res judicata be sustainable where you have been dismissed on the basis of dispute of fact?
Exactly, Justice.
In what way?
Because it will be the same matter starting afresh with same issues. So it will be a res judicata, Justice, if it's dismissed. Unlike if it is remitted back, then
All
it's
right.
a continuation of the same matter.
All right. Thank you, Ms.
Thank you. Thank you, Justice.
Thank you. I understood you, counsel, to have indicated that you were done, but I needed to check if my colleagues still had questions. Am I correct? From your side, you were done?
Yes, I'm done with my submissions, Justice. I
Yeah.
stand my written submissions.
Yes. I don't think there are any further questions from my colleagues. We are at 11:15. We are going to take the tea break now and resume at 11:30, and then we'll continue at that time. The court adjourns.
As a court please.
Court will adjourn until Court will adjourn until 11:30. Please note that during the adjournment, you're welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:30. Should you exit, you may use the same link to rejoin the meeting.
Are we all back? It looks like we are all back. Okay, Mr. Mukhari, I give you the opportunity to address us. We will not interrupt you for the first 10 minutes. And then after that, we will start asking questions. Please proceed.
Thank you, ACJ. I will use the opportunity of the 10 minutes to deal with the pertinent issues, taking into account what was brought before the High Court and what culminated in the judgment, which is the subject of this leave to appeal. I'd like to start by pointing out what this court has before reiterated a well-established principle that a party is not permitted to change its case on appeal. And that is for good reasons, because the dispute that falls to be adjudicated by the court is defined by the pleadings that are before the High Court, as well as what happens when the matter is argued. In this matter, as Justice Matopo correctly identified, the pertinent paragraphs 31, but I'll also add 32 at page 435 of the record. The High Court said the following, which has not been challenged by any means. At the hearing of this matter on 15 October 2020, and during oral submission, I raised a question to the counsel for the applicants concerning the numerous disputes of facts raised by the respondents, the substance of which cannot be decided on the papers. Counsel considered to the existence of material disputes of facts, and thus rendering the issue common cause between the parties. When asked how to resolve the issue, counsel submitted that since Rule 53 of the Uniform Rules of Court prescribed that judicial reviews could only be made on application, the applicants did not have a choice but to follow the procedure despite the existence of the disputes. So that is what was before the High Court. And that is what defined the parameters within which the High Court was to determine the matter. The High Court was informed that yes, there are material disputes of fact which cannot be resolved by the court on motion on the papers as they stand. And the question was, what next? And that is what confronted the High Court. We must also bear in mind that this concession was made by counsel on brief, who is not counsel today. It was made by counsel, was briefed by a different set of attorneys who were attorneys then, who are not attorneys today. So the point I'm making is that it is therefore not permissible that a case can be changed on appeal simply because initially the case was dealt with in a different manner. But I would like to read paragraph 32 as well of the judgment. Counsel for the applicants further submitted that since a litigant is not given a choice as to how to bring a judicial review, the court confronted with material disputes of fact should not adopt a robust approach by dismissing the application, but is expected to refer the matter to oral evidence. So after this, that is now the hearing of 15 October 2020, we can see just by reading paragraph 31 and 32 what happened that day. The parties were at addendum that their material dispute of fact and can't be resolved on paper. And the question was, what's next? And counsel for the applicants then said, we had no choice, but we had to bring the matter this way because we are obliged by Rule 53 to do so. But we now know from the proper concession that has been made by counsel for the applicants today that that submission was legally incorrect. It has no legal foundation because Rule 53 is not peremptory. We have referred in our heads of arguments to the judgments, which we understand that they also form part of jurisprudence, which becomes our law or part of our law. So we know in terms of our own jurisprudence that a party is not obliged to bring review proceedings through Rule 53 or motion proceedings. In fact, in the Nelson Mandela Bay judgment that we've referred to in our heads, the court pointedly said and mentioned action proceedings. And as Justice Matopo correctly pointed out that at the beginning, when you initiate proceedings, you decide, and you have to make an election as to whether you're going to go by way of motion or by way of action. Of course, subject to what the statute say. I'm alive to the fact that there are certain matters where you are obliged by statute to come by way of motion, like in liquidation, for example. But we're saying that subject to what the statute say, you decide. And what is going to determine the decision that you take is going to be the material dispute of fact, whether present or absent. And this is the election that was always available to these applicants, which then they say that, and they don't even dispute that they were aware from the beginning when they launched the proceedings that there will be material disputes of fact which can be resolved on paper. In fact, they concede that they themselves referred a dispute to the Hatla Commission because they understood that it is a type of a dispute that they will require the commission to deal with and, if possible, make appropriate recommendations. So the issue of whether they became aware later in the proceedings doesn't arise at all because it was never disputed that they were aware from the beginning that their material dispute of fact, but they only chose this mode of litigation because they believed wrongly that they were obliged to follow that procedure. So we submit that the issue about the Rule 53 then falls by the wayside. The only issue that this court is called upon to consider is whether the High Court correctly dismissed the application on the basis that it refused a midway application for referral for oral evidence. But the issue was, well, you knew from the beginning about the existence of dispute of fact. You ought to have made an election then. You don't when you are midway and you are confronted with the questions from the court. You then say to the court, oh, then I'm asking you to refer the matter to oral evidence. The court dismissed the matter on that basis, not on the merits, just on the basis that there are material dispute of fact. And this brings me to the question that Justice Matopo raised with our learned colleague for the applicant. Does this render the matter res judicata? The answer is an emphatic no, because the matter was simply decided on the basis of that there are disputes of fact which can be resolved on paper. The applicant is always at liberty to start the process afresh, follow then the correct procedure that will enable the court to resolve the disputes. Of course, we can't prescribe to the applicant what to do. Maybe when it starts afresh, it will make sure that it minimizes the dispute of fact, or it ensures that they don't arise. If they do arise, that they are not of such a nature that they can't be resolved through +1 events test. But that is for the applicant to decide. But what the applicant can ask the court to do is to say that refer the matter back for the High Court then to deal with the matter, when in fact then the High Court exercise a judicial discretion as to whether to refer the matter to oral evidence or decline to do so. And we're aware that, where a court has a discretion which it is entitled to judicially exercise. The appeal court does not likely interfere with the discretionary power of the court. A referral of the matter to oral evidence or a refusal thereof is a discretionary matter by the court, unless if the court is convinced, the appeal court is convinced that the High Court acted out of kilter. But in absence of any, and we don't see any submission that has been made emphatically to demonstrate that the High Court exercise a discretion in a manner that requires the interference by the appeal court, then the matter then simply falters purely then at that level. So I'm going to approach the matter then at that level, that the High Court only considered the issue of whether the matter should be referred to oral evidence or not. And you have seen in the heads of arguments, we have dealt with the relevant authorities, which dispel the notion that a party can simply midway the proceedings when hitting the brick wall to now request that the matter be referred to oral evidence. And I refer to our heads of arguments.
I just mentioned, counsel, that the 10 minutes is up. You may proceed, but you might start getting questions from the justices, but you may proceed.
Thank you very much, ACJ. So I was saying that we dealt with the relevant authorities which apply to at what stage a referral to oral evidence may be requested, whether then that is something that is akin to an interlocutory in a form of an in limine that will be made. We have referred from page 22 of our heads, paragraph.
Mr. Mkari, yes. Can I just ask you something? It arises from the questions that I asked. My understanding from counsel for the applicant is that they chose Rule 53 because of the benefit of having access to the record. Now, in her response, counsel for the applicant, and I apologize if I didn't hear her correctly, she seems to be suggesting that the first time the applicant was aware that there was a dispute of fact was when the JP mentioned it. And my reading of the affidavit from the respondent, it seems to me that that affidavit raises disputes of fact. Am I correct in that reading? That it
Yes.
it did not become apparent for the first time when it was raised by the JP, but when you filed the affidavit.
Yes, absolutely. Justice Chiki, you're absolutely correct. In fact, the issue was pertinently raised in the papers. I mean, we can see that from page 359, is it 359? From page 359 of the record. Once the affidavit of the respondents becomes apparent that the disputes of fact are of such a nature that are material and cannot be resolved on paper, in the replying affidavit, the applicant is at liberty to then say that in the event that the court is not able to resolve these disputes, applying the plus connivence test, then I am applying referral to oral evidence. I mean, that's how it's done in practice. So that has always been known to the applicants. All what the court does when the proceedings commence, and the court is at liberty to do that. Actually, the court does that all the time. I see that there are disputes of fact here. It's up to counsel to convince the court that no, the way you're seeing the matter, then I mean, you're not seeing correctly. And I would like to persuade the court to demonstrate to the court that these are not the type of disputes of fact which cannot be resolved on paper. It is up to counsel to do that. But in this matter, that is not how the proceedings ran. What happened was that then counsel considered that yes, there are material dispute of fact. All what the court was doing was simply to raise what was already apparent in the paper. So it's not correct that we are now told for the first time that the disputes of fact only became apparent when the JP raised that issue in court. So that would be
Thank
my
you,
answer.
ACJ. Thank you, ACJ.
Mr. Makara.
Justice
Thank you,
Theron.
Justice Theron.
Thank you, Acting Chief Justice. Was there any disputes of fact in the High Court as to the following two issues? One, whether or not the Premier referred or that the Premier did not refer the Khatla Commission recommendations to the Provincial House of Traditional Leaders, and the Khatla Commission did not issue its recommendation within the 5-year period.
Well, the answer to the two questions is that, and that can be discerned from the paragraphs that I've read from the judgment, is that once the issue was raised by the court that there are material dispute of fact, the council immediately considered, and the court did not ventilate other issues. Neither did council say that, yes, I understand that there are factual dispute of fact.
I'm sorry to interrupt you, but I am cognizant of time. Were there disputes of fact? Are you able to answer my questions, please?
Yes, there were dispute of fact. So what I'm saying is that—
Were there disputes of fact that the Premier did not refer the Khatla Commission recommendations to the Provincial House of Traditional Leaders? Was there a dispute of fact that the Khatla Commission did not issue its recommendations within the 5-year period?
Well, Justice Theron, I understand your question that you want yes or no, but I'll not do justice to it if I say yes or no, because I want to contextualize it in the context of what happened, that once then the council considered that, yes, there are material dispute of fact, council did not say that, yes, there are disputes of fact, I accept, but there are legal issues which do not even require you then to consider dispute of fact. There are these two legal issues which can be resolved on paper and the court can simply deal with it. So that did not arise. So that's why then I'm not in a position to say that.
Mr. Makara, my question is not whether this was raised by counsel in the hearing before the High Court. My question is, as we sit here, as we review the papers that were before the High Court, was there disputes of fact on the papers regarding those two issues?
No. But my no is going to require why there was no dispute of fact, and that issue was not argued before the High Court. And I can give an example to you. For example, I'll say, in respect of the allegation about the Khatla Commission having outlived its lifespan, we have dealt with that issue in our heads of arguments, as you will have seen, footnote 54 and footnote 55. And we refer to a government gazette, which actually deals with the extension of that commission. And if you look at how the issue
was raised for the first time in this court, Mr. Makara. That was not raised in the High Court. And that's why my question to you specifically was on the papers before the High Court.
I'm sorry. Let me see.
Understand you. Then, so that's
hang on, counsel. Let me see if I can assist on this question.
Yes.
Mr. Mufari, are you able to direct our attention to your client's answering affidavits and tell us where they raised a dispute of fact on the issues that Justice Theron raises in the affidavit, in their answering affidavits?
No, they didn't deal with that.
Okay, all right. Thank you. Justice Theron, I don't know if that assists.
Thank you, Acting Chief Justice. Now, the question whether or not there are disputes of fact, is that not a legal question? If it is a legal question, then is the applicant bound by the concession that was made by their legal representative?
Well, it's a legal question that is intertwined with the merits. So that's why I'm saying that had the issue arose in the High Court.
If it is a legal question, Mr. Mukari, if it is a legal question.
It is a legal question.
Is the applicant then bound by the concession made by counsel if that concession was wrongly made?
No, there was no concession that was wrongly made. The concession that was made was on the factual disputes, that the material factual disputes, and the legal issues never arose. So that is my answer. As to the issue pertaining to whether the court is to decide the two legal points separate from the merits, it never arose. If it arose, the respondents will have had an opportunity to deal with it. So hence, then the respondents are now supposed at the appeal stage to deal with issues that never arose in the High Court when then they are here then confronted with the High Court judgment which approached the matter on the basis of what the parties have directed the High Court to do. So that is really the position.
At paragraph 53 of the judgment, the High Court said that the application is without prospects. Does that render the dispute res judicata?
Well, what the court say, obiter, and the ratio decidendi of the judgment should be differentiated. Are you
saying that's obiter, Mr. Mokara?
No, it's obiter. No, it's obiter because what the court was called upon to decide was whether to refer the matter to oral evidence or not. So that is very clear from the judgment. That's why the court said, can you submit supplementary heads dealing with whether the matter should be referred to oral evidence or not? And especially when you look at the last paragraph of the judgment, so it is clear that it says that there are material disputes of fact which cannot be resolved in paper. And I say that.
Refer you to the first sentence in paragraph 53 of the judgment, Mr. Makara. Paragraph 53 says, on the conspectus of the evidence on affidavits in the matter, the applicants have shown no prospects of success. Do you maintain that's obiter?
Yes, it's obiter because it is in the context of the material dispute of fact. So then in the context of the material dispute of fact, then you have shown no prospect of success in succeeding. So that does not render the matter res judicata.
Where does the absence of prospects appear to be limited to the disputes of fact?
The prospect of success.
Because the judge says, on the conspectus of the evidence.
Yes.
And linked to that, isn't it that the fact that there were no prospects led the court to refuse the referral to oral evidence? Or that the court considered there were no prospects?
Yes, no, I mean, of course, before you can conclude that there are no prospects, you have to look at the conspectus. I mean, that's how it has to be. So it must. So I don't think you can even reach a conclusion that there are no prospects without looking at the conspectus. So in the totality of, and that's what you have to do. So let's look at the same paragraph so that we read the whole of it. So that we don't just read only the first part of it. On the conspectus of the evidence, on affidavits in this matter, the applicant have shown no prospect of success. The parties have appeared and testified together with their witnesses before the Khatla Commission, where they were subjected to questioning or cross-examination. The first applicant came out second best in the evidence before the commission. His credibility was questioned and his evidence was labeled unreliable. I do not foresee the first applicant improving from his poor performance before the commission, lest he perjures himself in his oral evidence before this court. So that's the conspectus that the court then took into account, that the very same applicant was there and the record or the transcript of his testimony is there. So there is nothing that is going to improve on that.
Hence my question, whether that finding that the application was without prospect rendered the dispute res judicata, because it relates to a finding on the matter as a whole, the composite matter that was before the High Court, not only on the disputes of fact.
On the conspectus. I mean,
Yes.
so we must emphasize the conspectus. On the
Yes.
conspectus, then that is the finding, and which is the correct one in my respectful submission, but nothing prevents the applicant, let's say then issue summons, is able to bring other witnesses that he say can bring. But before the High Court, the applicant never said that I actually then will be able to bring witnesses who will be able to augment what I've told the Carter Commission. So I'm saying that on the conspectus of what was before the court, but we can't speculate about what the applicant can put forward later when he decides then to pursue the matter and using then the avenues which are permissible in law.
Thank
so
you.
I agree, it is the conspectus that is the defining in this judgment.
Mr. Mukari, just as a follow-up, if you are correct on that point that there the court was dealing with the referral, para 55 seems to be clear. The court there says on the merits of the application, I am of the view that the applicants have not made out a case for the relief that they seek in this application.
Yes.
The dispute of fact is such that the matter should be decided in favor of the respondents. Is he not dealing with the merits now of the actual application?
Yes, he's dealing with the merits in the context of whether referral should be allowed or not. Because what is very important that we have to take into account is that these were motion proceedings, although we understand that Rule 53 is motion proceedings sui generis. So because of then you have the record and you have the second bite of the cherry then with the supplementary affidavit. But here the court is dealing with the disputes of fact where you have two contesting parties having put two contrasting versions. So on that alone, you are not able to find in favor of the applicant because the applicant is the one who bears the onus of proof. So he's saying it in that context. So the context that is very important.
Look at the last sentence at para 54, where he says, yes, accordingly, the request to refer the matter to oral evidence is refused. Then you read para 55, where he now talks of the merits of the application. Surely he can't be still referring to the oral evidence, the referral to oral evidence.
It's just in Santa again. I think maybe I was speaking cross purposes. It is the merits in the context of the referral because of the material dispute of fact which has been considered cannot be resolved on paper. So yes, there's no way in which the court would have written a judgment of this nature without considering the merits. So it is the merits of the matter, but the court focusing on what has been considered, that there are disputes of fact which are material, and the court is saying that looking at these two versions which are contrasting from these two parties, I cannot find in favor of the applicant. Otherwise, then the court will have no way in which it can come to a conclusion, because either it must say, I find in favor of the applicant because then this dispute of fact are not material and they are in favor of the applicant has discharged the owners, or I'm not able to find in favor of the applicant because the applicant did not discharge the owners. So that is the basis upon which the matter gets dismissed. But I am still content that that does not rest the matter in the context of res judicata.
Mr. Mukari,
well, I'm sorry, Justice Matopo. Mr. Mukari, isn't the position that when the court decides to refuse referring a matter to oral evidence, it can't leave the matter hanging? It must still decide the matter on the merits, but then it must decide it on the merits of on the version of the respondents.
Absolutely.
So
Absolutely.
Its decision has to be on the merits ultimately, but the merits are based on the version of the respondents insofar as, in other words, insofar as there are disputes, then it's the respondent's version that prevails. And so ultimately the court decides the matter on the merits, but the applicant will lose out most, if not all the time.
Absolutely. Actually, then let me put it differently. Let's take, for example, the pleadings have closed. With the founding papers, of the answering papers, of the replying papers. The pleadings then have closed. The matter is ready for the court to adjudicate. Then the other party says there are serious dispute of fact, and I'm giving an example where the applicant does not request referral to oral evidence. Then the court says, I think that there's serious dispute of fact here. Then how am I going to resolve this dispute? And the applicant says, I'm going to persuade you to show that these disputes are not of such a nature that you can't decide this matter on motion. At the end, then the court will still come to the conclusion and say, I find that there are serious disputes of fact which can be resolved on paper after analyzing the merits. And therefore, then the applicant is faced to discharge the onus, and therefore the application must be dismissed. So at the end, the application is dismissed on the merits. But I'm just saying that in the context of this matter, it is because then the applicant has midway requested or then referral to oral evidence. That's why you'll have this paragraph or this line in paragraph 54 at the end, which says, or a referral to oral evidence is refused because it was asked for. But the matter ultimately is dismissed on the merits, and that's the submission that I'm making.
Yes, Justice Matopo, I interrupted you, I'm sorry.
Thank you, ACJ. Mr. Mkari, if you look at paragraph 47 of the judgment, there's a heading there which leads us to the conclusion that you have been debating with my colleagues. It says, should the court refer the matter to oral evidence or dismiss the application? And JP Makuba goes to the extent of quoting all the cases, and then he ultimately come to the finding that the case had to be dismissed based on the dispute of fact. I want to draw your attention particularly to paragraph 52 of the judgment, wherein it is stated, I'll read it out. A decision to hear oral evidence, it's premised on the question whether there exists prospect of success for the applicant seeking such a relief. And then he quotes Khalil versus the Codex, and then he deals with paragraph 53 and paragraph 54. The essence of his judgment, as I understand it, you'll tell me if I'm correct, is that he was purely dealing with a dispute of fact, which he had requested the parties to submit supplementary affidavits to deal with the question whether there exists a dispute of fact or a referral to oral evidence or not. So this judgment, as I understand it, relates to that particular point where he has drawn counsel's attention to it. Tell me if I'm correct.
Absolutely, you are absolutely spot on, Justice Matopo. That is precisely the crux of my submission.
Well, let me just follow up on that because I'm not sure that I understand your answer to Justice Matopo and your answer to me earlier on.
Yes.
As a matter of law, when a court deals with a motion matter and the issue of disputes of fact arises, and there's a debate about whether the matter should be referred to oral evidence or not. If the court concludes or refuses to refer the matter to oral evidence, what is it supposed to do? One, should it stop there? I refuse to refer the matter to oral evidence. That's it, and leave it to the parties to do what they want to do? Or is it then obliged to deal with the merits of the application and bring an outcome out of that application on the merits, or is it free to simply say, I refuse to refer the matter to oral evidence and say nothing else? And if it can do that, what then happens?
Yes, thank you, ACJ. Actually, I now understand the slight distinction between what you say and what Justice Matopa has said, but you're saying the same thing, but you only differ in respect of what is the effect of the dismissal. So then in your case that you have just put forward, it is exactly then the same case as what Justice Matopa has said, is that at the end you have to dismiss the application because you have to consider it in the context of the merits as they stand with disputes of fact which can be resolved on paper. So you're dismissing it for that reason and no any other reason, because the applicant is a dominus litis who must discharge then the owners. So when you have then the material dispute of fact, the conclusion is that the applicant did not discharge the owners. But as I said, context is everything. You have to look at the context within which that order of dismissal has been made. And that then becomes the material difference.
Are you saying that the dismissal of the application in that case does not have as its foundation the factual version advanced by the respondents, but its basis or foundation is simply that there are disputes of fact. I can't resolve this matter in motion proceedings, and therefore I'm dismissing it without determining the real dispute that was brought before the court. I'm not determining the real dispute. Does it amount to the dismissal? Does it amount to determining the dispute that was brought before the court to determine, or does it not amount to determining that dispute?
Well, you, as a court, you'll have dealt with the matter on the common cause of facts that there are material dispute of fact, and that is how, as a court, we have approached the matter. So you are dismissing it on the basis that the disputes of fact which are here are of such a nature that I have to dismiss the application because it means that the applicant then didn't make out a case. But because of the context, the applicant is not hit by res judicata, because the applicant will be able to motivate and say that my application was dismissed on the basis that there are material dispute of fact which cannot be resolved on paper, that what I placed before the court was not sufficient in order to allow me then to escape a plus con evils test. So I am now coming to court by action, and I'm able to produce evidence which will discharge the owners. So that's the distinction then really.
If your submission is correct, what it would mean is this, and I just want you to indicate whether you agree that this is what it would mean. It would mean that despite the fact that the parties have filed all affidavits that they wanted to file, ventilating these issues and dealing with all these facts, the court, when it refuses to refer the matter to oral evidence, is actually saying, well, I'm refusing to refer this matter to oral evidence, but you are free to start all over fresh, all over again, if you want to, by way of an action. So ultimately, you will get to have oral evidence on the matter, but you'll have to start afresh. So I'm just wondering why a court should do that. You have a situation, you may have a situation where the dispute has been going on between the parties maybe for a year before the matter is before the judge in the High Court. All affidavits are in. Nobody says there's a witness that I still want to get. All affidavits are in. And everybody can see what the disputes of fact are. But the court says, I'm not referring this matter to oral evidence. But it knows that you can, the following day, you can issue a summons and the whole process starts again. And the same parties will end up before a judge with a lot of these same documents being before the judge. And then there must still be oral evidence. There will be oral evidence led. Another judge, maybe the same judge or another judge will then be seized with the matter. It doesn't seem to me to be something that would ordinarily be in the interest of justice, as opposed to saying, well, all affidavits are in. None of the parties says, I want to call another witness or I want an affidavit from another witness. All affidavits are in. We know what the disputes of fact are. This dispute has been going on maybe for a year or more. It makes sense that it should be referred to oral evidence now. It's better use of even judicial resources to have it decided and referred to oral evidence now, rather than dismiss this application in circumstances where the dismissal of the application is not a determination of the real dispute. It's simply saying, go start all over again and spend another year or two and come to the same point again. I have some difficulty with the rationale for an approach that allows that situation to happen.
No, I understand. I appreciate that. I mean, ACJ, and I think your difficulty arises from maybe that you didn't understand the context that I'm putting.
Yeah.
Well, let me say, when I say that your door is not closed, I don't mean that you're going to succeed as an applicant. So that's what I'm not. So I'm not saying that. So all I'm saying is that you are not stopped from doing whatever you want to do. Whether you're going to succeed or not is a different thing altogether. And the proposition that you're putting of everything is in, all affidavits are in, none of the parties is saying that I want to put further evidence. That actually was the problem of the applicant. Because had the applicant said, I have evidence that I can put, then the court will have been obliged to consider that evidence. I mean, it's the same thing when a party applies to lead further evidence. The court doesn't say, okay, you say you want to lead further evidence. Okay, it's fine, then you can lead it. The court asks you, what evidence do you want to lead? Because the court has to be satisfied that it is relevant. So here, we must read the judgment in conjunction, particularly paragraph 52, which Justice Matopo has read. That is where the court now has explained that this applicant who now midway say that refer to oral evidence doesn't tell me of anything new that is going to say. Hence, it concludes by saying that there is nothing that is going to improve this case because he has already led evidence and nothing. So then that context is very important. But your proposition in the abstract, then I accept it, of course. But here, when we look at this judgment, the court didn't simply say that, well, I'm just dismissing you. Then it dealt with the process of success and say that you're not telling me of anything new that you're going to say which is going to improve your case as it stands here. But had the applicant said that, the High Court was obliged as a matter of fairness and law to consider that, and if it rejects it, to be evaluated and assessed by this court on a basis whether its refusal was reasonable or not.
Mr.
Yes.
Makhari,
Thank you.
through you, ACJ.
Justice Toronto? Yes.
I wonder if we could just take this in steps. Am I right in saying that when an applicant understands that there are disputes of fact, it has an election to make, either to seek a referral to oral evidence or to proceed with the matter and perhaps hope that it can argue points of law which don't depend on the disputes of fact? Is that correct?
Absolutely, you're absolutely correct.
Yes, and so if the applicant doesn't choose to proceed but asks for the matter to be referred to oral evidence, it invites the court to exercise a discretion as to whether to do so or not. Is that correct?
Yes, yes.
In the context of review proceedings, though, when a court is confronted with a request, even if it comes late, should a court not be very careful about refusing to refer a matter to oral evidence in the context of a review because of the advantages which our courts have recognized of applicants using Rule 53 to procure the record and getting to a state where things can be sometimes determined much more quickly than by way of a trial action?
Yes, can I respond?
Yes, please. I'm just asking, in other words, whether particularly in review cases, as opposed to other kinds of Rule 6 cases, courts should be very careful before they refuse to allow a matter to be referred to oral evidence if there are disputes of fact which are relevant to the determination of the merits of the review. That's the proposition. I'd benefit from your answer.
Yes, yes. No, I mean, I don't think that the proposition is one that one can disagree with. I mean, in the abstract, I mean, in a sense that the court has to carefully consider the request and guided by the law in pertaining to that particular issue. In a review, the court is even in a much better position than in a strict Rule 6 application, because in a review already, the record has been dispatched. Yes. So there is a record which is already there. So the court is in a better position of what is it which still is needed for the court to determine the matter over and above what is already in the record. So yes, that is what we have in this matter. So in this matter, the court had the benefit of the record.
But then let me interrupt you. If the court, notwithstanding the fact it should be careful in not referring a matter to oral evidence where there are disputes of fact in a review, if it decides not to do so, then it's got to apply Plascon-Evans and say, together with the record, I take the respondent's version and I then determine the matter on the basis of the respondent's version read with the record. But that is not what appears to have happened in this case.
It is, well, I think it arises from how the matter progressed on the 15th when the matter was called. Well, if it did not progress in the manner in which it did, where the court had to deal with the issue of the dispute of fact, then the court was simply going to proceed and deal with the matter.
But it didn't. You see, it didn't say, well, I will now take the version of the respondents. I will use that as the factual basis for then considering the review and then make a determination. It just said, I'm dismissing this because I don't think there's a basis for referral. It's never going to get any better, but I just dismiss it because I think on some basis that's not articulated. They're on prospects. You've got to go through the exercise of determining the review on its merits if you're not going to refer the matter to oral evidence, and that's not what happened here.
Well, if we look at paragraph 52, right with 53 and 54, that, in my respect for submission, provides then the.
But those aren't reasons. Those are just. I'm sorry to interrupt, but those are just conclusions. I mean, we know that there are questions of interpretation of the provincial and national legislation, and the grounds of review that have been raised and the facts that arise in this case, but none of that is traversed.
Yes, that is not traversed because of the manner in which the proceedings unfolded on that day. So once then the proceedings take a particular direction and everybody is added with that, that is how then the matter is going to be dealt with. I think that is what then really has happened. But what the High Court can be criticized for is for it reaching a conclusion of dismissing the application because of the dispute of fact which were apparent on paper.
Thank you for your assistance.
May I follow up on that, please?
Justice Majid, please follow up.
Yeah, thank you, ACJ. Mr. Mokara, I just want to follow up on that. In Helen Suzman Foundation, this court expounded on the advantages that an applicant in a review application has in adopting the Rule 53 notice of motion procedure. One of the things this court said is that it enhances the right of access to justice because it enables a litigant to have a very clear picture, not to grope around in the dark, as the court referred to it, when it launches review proceedings. The complete record is there, as opposed to documents which are relevant to the issues, as would be the case in the Rule 35 discovery. Now, in this case, the applicants say they needed the record, and I think it's self-evident why they needed the record, and they needed the full record, so they proceeded by notice of motion. Now, if we accept against them that they must have foreseen there would be a material dispute of fact, such as the one on genealogy, and yet they proceeded, why should they be punished for following that procedure when they wanted the record, bearing in mind what this court said in Helen Suzman Foundation?
Yes, in fact, thanks, Justice Majid. The applicant is not punished. If you look at the advantages which are there in Rule 53. Rule 53, as I've said initially, is motion proceedings sui generis. And I say that the only thing which make those proceedings sui generis is because, one, it allows you a second bite of a cherry by putting a supplemental affidavit without leave of the court. And secondly, getting discovery, which you don't have to go through Rule 35, because the record that you get under Rule 53, that's discovery. So it gives you that benefit. And then and remember, Justice Majid, that the rule is structured in such a manner that the record and the supplementary founding affidavit must come before the respondents come into the picture. I mean, you'll see when you read Rule 53, unlike Rule 6, it doesn't tell the respondent to file notice of intention to oppose within 10 days of receiving of service of the papers, and that's for good reason.
I'm sorry to interrupt you, Mr. Mokari. I think we all understand the rule very, very, very well.
Okay, let me come straight to the question. Let me come straight to the answer.
It just seems to me the question of the penalty is the one I'd like you to focus on, please.
Okay, let me come straight to that. But I wanted to give this background so that you can, contextualize in my answer. So I'm saying that the moment the respondents file an answering affidavit and the dispute of fact become apparent, the applicant in the...
Sorry, Mr. Mokari, there's an echo.
There is some feedback.
Advocate Monyemoro.
Counsel for the applicants. Counsel for the applicants, there seems to be some noise that comes from your background.
She has muted now.
She has muted now.
Yeah.
Thank you, ACJ.
Okay,
sorry,
right.
Mr. Mokari, sorry about that.
Yes, so let me come direct to the issue of the penalty. So I'm saying that the moment the respondents file the answering affidavit and the dispute of fact become apparent, in the replying affidavit, nothing stops the applicant from saying that I am going to apply to have this matter referred to oral evidence. So the same procedure that is invoked in Rule 6 about how a matter is referred to oral evidence is the same procedure that you are going to invoke in Rule 53. There's no difference at all. So there's no penalty there, because whilst you have the avenue of an action proceedings, but if you have gone by way of Rule 53 because you wanted the advantages attendant to it, when the dispute of fact arises from the answering affidavit, you then apply of referral to oral evidence, and nobody will refuse you that.
Well, it happened in this case. Mr. Mokari, let's see, in addition to what my brother Justice Unteralter has put to you about the complete dearth of reasoning in this judgment when it comes to the merits, I'm not talking about disputes of fact. In addition to that complete absence of reasoning, let us look at page 449, paragraph 54 of the judgment of the High Court, where Makgoba JP says the following, and I quote, "The applicant's remedy lies in an action procedure, and the election to proceed on motion was fatally misconceived from inception. A referral to oral evidence will not serve to cure the deficiencies of this matter in an expeditious and just manner. According to the request to refer the matter to oral evidence is refused." Now, I must tell you, I've yet to come across in my days at the bar and on the bench of a Rule 53 of a review application launched by way of summons. I've never seen one. And it seems to me that given the absence of reasoning and these statements of facts in paragraphs 53, 54, and 55, that what has happened here is simply unjust, because what happens is the court says you went on a Rule 53 application on notice of motion for seeing material disputes of fact, and for that very reason and that reason alone, I dismiss the application. Is that not what happened here?
Yes, well, I mean, let me first deal with the first one when you say you are yet to see a review brought in action, but I'm sure you're not suggesting that it's not permissible. So the mere fact that it is not there then doesn't mean that it's not permissible. So it is permissible, and I mean, most of the time, jurisprudence is developed then by litigants, because litigants are the ones who bring matters to court, and that's where we're going to have judgments and we're going to have precedents. So one day then you'll find it, and then of course it will be adjudicated. So it is not really then a taboo or a bar, then it's not a legal bar. But in any event, here, what the justice, what the JP was dealing with in paragraph 54 was the context in which the dismissal or the refusal to oral evidence then the referral to oral evidence then arises. So, well, then I don't know what would be the criticism there, given the fact that one can read paragraph 54 in isolation from the rest of the paragraphs that appear then above. But as I've said, Justice Majid, there is a referral to oral evidence, which is an application that can be made and can be considered and granted. And I would like to correct Justice Majid when you said that in this case, it happened that the applicant was refused. The applicant was refused because he applied for referral to oral evidence at the tail end of the proceedings when he was hitting the brick wall. And we've referred in our heads of arguments, case law, which says that you can't do that. You must actually then apply at an appropriate time, unless then if those cases are wrong. But if they're not wrong, then we submit that, I mean, those cases were correctly relied upon by the High Court.
Okay.
So it's not that the court refused to refer to oral evidence because it said that it is not permissible under Rule 53. That is not what the court was saying. It refused because it said that you brought it too late when you were confronted with this dilemma.
Yeah, I hear your argument. I just want to ask you, can you show me in the judgment where the High Court reasons out the issues that were raised in terms of Section 30 of the Limpopo Act, the issue in terms of the Khatla Commission's length of term of office, and also the Khatla Commission's interference, as it is called, in litigation, where litigation is instituted in the course of the Commission's proceedings? Where is it reasoned out?
No, I didn't deal with that at all because of the manner in which the proceedings unfolded. Remember, Justice Majid, counsel are there to assist the court and they play a very important role. When counsel say to the court, this is how we would like the matter to be adjudicated, then the court follows that it doesn't follow that the court will then say that I'm taking a different line in order to deal with the matter. So councillors have an important role. They are there. They say that we're happy that the matter must be dealt with in this particular fashion. And I have no doubt then, Justice Majid, that had counsel for the applicant said that, I hear what you're saying about dispute of fact, but there are these legal points that I want to argue. And I have no doubt that the court was not going to stop counsel then from arguing those legal points, either grant or dismiss them on that. But that was never even canvassed. That's why then the parties were never given opportunity to deal with those issues. And so then for them then to be dealt with at this stage and for us to be confronted with them at this stage, then it becomes really then rather difficult than task than to do. Well, I mean, I appreciate that what the court may be pondering is whether these points should be referred back then to the higher court so that they can be argued and considered. Of course, this is within the discretion of this court. If this court then believes that these points can be dealt with there, it can be, because it may even give parties an opportunity if they want to supplement their papers or whatever, then they can do that. But we're just looking at whether then there is a rational basis that has been advanced by the High Court in refusing to refer the matter to oral evidence, given that this is a discretionary matter which falls squarely within the discretion of the trial court. In this case, I'll say that the motion court, because it was sitting as a motion court, and the discretion can only be interfered with if it is of such a nature that it can't be defended at all.
Just in the interest of time, Mr. Mokari, one last question. Section 30 of the Limpopo Act. Do you accept that that section is framed in peremptory terms? It says the Premier must, in 1, and the Provincial House of Traditional Leaders must submit, and in subsection 3, the Premier must implement. Do you accept that is a peremptory provisions?
I will say that again, it is linked to the fact in this case. It is peremptory, but it is linked to the fact in this case. If an opportunity was given to the respondents to deal with it, they would have dealt with it. And I'll tell you how then the respondents are going to deal with it.
No, before we get there, I'm just speaking in principle.
It is peremptory, of course. It is peremptory, yes. Now, non-compliance of those provisions, what would be the effect then if those provisions were not complied with? Well, if the just as a matter of principle, we're not talking about this case now. Well, it's a matter of, it's not even a matter of principle, it's a matter of law. I mean, it's a matter of law, then I mean, if it's peremptory, it's peremptory. I meant as a matter of legal principle. But anyway, Mr. Mokari, so what is your defense in this case on the Section 30 issue that was raised by the applicants? Well, I mean, like I said, that because this was not dealt with in the High Court and would have dealt with it, then let me briefly just make submissions on that point. Sorry, I thought the applicants raised it squarely in their papers. Yes, now I'm saying that. I'm responding to that. I'm saying that the Premier recognized the 5th respondent on the basis of the appointment that was made by the royal family on the 8th of March, 2018. The Premier did not appoint based on the recommendations of the Khatla Commission. Rather, the Khatla Commission only dealt with the dispute or the complaint that was raised, which was taken to the Commission by the first applicant. And it made a finding that he didn't establish that, and it recommended that his thing be declined. So there was no finding which said that somebody must be replaced by another body. So the recognition does not arise from what Hatta said. It arises from the appointment, and I'll give you the page number of that of the resolution of the family. You'll find it at page 368, 369, and 370. So when you look at it, they have appointed the 5th respondent. And in terms of the Framework Act, what the Premier is required to do is to recognize. So it is the family that appoints, not the Premier. So the Premier didn't appoint. So we're saying that this was not an appointment which arises from implementation of the recommendations of the Khatla Commission. But I'm saying that had we been given opportunity to deal with those issues in the High Court, we'd have dealt with them and would have demonstrated to the High Court that this is an appointment by the family, recognized by the Premier when he accepted that.
Yes, thank you, Mr. Mokari. Thank you, ACJ.
If I may follow up, Acting Chief Justice.
Thank you. Yes, Justice Theron.
Thank you, Acting Chief Justice. On the last question that was put to you by Justice Majid, Mr. Mokari, can I refer you to volume 1 of the record, please?
Of the report.
Of the record.
Of the record, oh, sorry.
Page 101, annexure MK12. The first applicant is advised of the outcome. If you look at page 102, please, paragraph 2. The Premier says.
Sorry, then I'm battling to find my 101 in my bundle. Can my juniors assist me on that?
The more important page is page 102, Mr. Mokari, of the same volume.
I think I'm missing 101, 102 to 105. But it's fine, you can proceed, just then whilst my junior are giving it to you.
That's a letter from the Office of the Premier. Paragraph 2 says,
I'm aware of that letter. Yes.
I have considered the findings and recommendations of the said committee, this in terms of the provisions of the Traditional Leadership and Governance Framework Act as amended. As a direct reference to the findings and recommendations of the Khatla Commission is the failure by the Premier. This is if we get to the Section 30 issue, is the failure by the Premier to refer the recommendations to the Provincial House. Does that vitiate his decision?
Not in this context, because we have to look at what is it that was recommended. Nothing was recommended there. If you look at those recommendations, we can actually go to those recommendations at page 20, I think it's 201 or so, of the Khatla Commission. It starts from 199, the report. And if you can go to page 213. Recommendations. On the basis of the evidence presented, the Commission hereby recommends that the claim of Mamadi for the restoration of Mamadi senior traditional leadership to the rightful lineage of Ramutsabi through his lineage is declined. So that's all what it does.
Yes, Section 30 says, before the recommendation is implemented, it must be referred to the Provincial House. Does the non-referral by the Premier, and it's accepted by the respondent that there was no referral to the Provincial House, does the non-referral not vitiate the Premier's implementation of the recommendation?
No, I think that's where we will differ than Justice Theron, because I'm saying the context of this report, there is no recommendation. I don't see any recommendation. When the Commission says that your application is dismissed, I don't see that as a recommendation. A recommendation is when the Commission says so-and-so must be removed and replaced with so-and-so. And I don't see it even saying that the fifth respondent must be the one who must be appointed.
Let's look at page 213 again, please, Mr. Mokari.
31?
Page 213.
Yes.
Paragraph 9, it's headed recommendation.
Yes.
That paragraph contains the recommendation of the Khatla Commission. Let's for a moment not look at the content of the recommendation, but that paragraph contains the recommendation of the Khatla Commission. Would you agree with?
Well, I was taught myself that headings mean nothing because it is the context, even the interpretation of statutes. You don't interpret headings. Headings, they may be misleading. Look at the content. So I'm saying that content.
Is it your argument on behalf of the respondents that the Gatla Commission did not make any recommendation?
It didn't make any recommendation which triggers Section 30. So that's what I'm saying.
Does that appear in the papers, Mr. Mokgare?
Well, it's a legal issue. That one is illegal. I'm arguing it as a legal issue, Mr. Cicero. Because I think that I should argue the legal points and then separate the legal points from the facts where they can be separated. But where they can't be separated, they must be argued together. Just a moment, then my junior is referring me to something.
Are you done, Justice Theron?
I still have a follow-up question. Thank you.
Oh, okay. Yes, you may put your follow-up question.
Acting Chief Justice, I think Mr. Mokgare has asked for a moment to consult with his junior.
Oh, I'm sorry. I'm sorry. I didn't hear that. I'm sorry.
I'm back.
Okay. Are you done? You're back?
I'm back, ACJ. I just want to conclude my answer to Justice Theron by referring to Section 26, we must also read Section 26, which pertinently deals with recommendations of commission, and 26 sub 2b. Let me read. It says a recommendation of the commission must within 2 weeks of the recommendation having been made be conveyed to, well, I'll skip A because A refers to the president, and the president I'll submit is in respect of the kingship or queenship, but here we're dealing with senior traditional leadership, so B seemed to be the one applicable. The relevant provincial government and any other relevant functionary to which the recommendation of the commission applies in accordance with applicable provincial legislation insofar as the consideration of the recommendation does not relate to the recognition or removal of a king or queen in terms of Section 9A or 10. So when one then reads Section 26 in its proper context, I'll submit that the recommendation must be a recommendation which are substantive in a manner that they say, like so and so is not qualified and is removed, and so is replaced. Like the situation that this court dealt with in the Langa judgment, which it delivered in November 2021. So in the Langa judgment, this court was confronted with a completely different type of recommendation. So here, all what we know is that the first applicant approached the commission, and the commission simply said that your application is dismissed, and that's all what it did. And the premier, when he appoints because we have not appoint, he recognizes because he has an appointment from the royal family of 8 March 2018.
Mr. Mokgare,
I'm sorry, Justice Theron, before you proceed, I just want to mention that we are at 1:45. Mr. Mokgare's 45 minutes ended at 12:15, but that is not to say that colleagues mustn't ask questions that they feel are important to ask. I just want us to be aware of where we are with time. Please proceed, Justice Theron.
Thank you, Acting Chief Justice. Mr. Mokgare, if I can refer you to Section 30, please, of the Limpopo Act.
Yes, I'm on it.
Yes. The heading says implementation of decisions of the commission. Paragraph 1 says the premier must, within 7 days of receipt of the decision of the commission. And here we use the words decision is used, and this is dealt with in the longer judgment as well. Decision versus recommendation. It says the Premier must, within 7 days of receipt of the decision of the commission, refer such the decision to the Provincial House of Traditional Leaders. Now, your argument was that the recommendation made by the Gatla Commission was not one that triggers Section 30. Was a decision made by the Gatla Commission as reflected in paragraph 9 of its report?
Section 30 of the Limpopo Act doesn't speak to Section 26 of the Framework Act at all. Section 26 talks about recommendations and Section 30 talks about decisions. Those are two different things. Recommendation and decision.
Can I repeat my question, Mr. Mukari?
Yes.
Did the Gatla Commission make a decision in this matter?
It made findings and recommendations. Findings are at page 212. Recommendations are at page 213. Findings are decisions. Recommendations are not decisions.
So should the findings have been referred to the Provincial House? Should the decisions have been referred to the Provincial House? Should recommendations have been referred to the Provincial House? What is your argument about that?
My argument is that in the context of what we see at page 213, which is the recommendation, and 212, this does not fall within Section 30. And those are the submissions that I'm comfortable with, because I'm reading the provisions of Section 26 of the Framework Act and the provision of Section 30. They speak to two different things. Section 30 says decisions, and Section 26 says recommendations.
And your submission is that's different?
That's different, yes.
Yes.
But again, as I say,
do you have any authority for that submission, Mr. Mukari?
Well, on whether there's a difference between decision and recommendations, that is a basic principle, which we have plethora of judgments on that. What is a recommendation? A recommendation is not binding, a decision is binding. We have a plethora of judgments on that.
Yes. Now, the recent decision of this court in Langa says something a little different to the submissions that you've just made.
Well, I have it. If you can refer me to the paragraph where it says something different, then it means that I've gotten the law wrong, or maybe then we'll have to slightly change it in the future.
Yes. But if you've read the judgment and you maintain your submissions, we've heard you, Mr. Makari. I don't think
I've read it, yes.
we should take that matter any further. In any of the answers that your submissions that you made to Justice Majid, you said that the cases that you rely upon and that you refer to in your heads of argument support the decision of the High Court to dismiss the matter on the basis of disputes of fact that cannot be resolved. Now, you will be aware of Rule 2 of the Paja rules.
Yes, I'm aware of it.
Yes. And Rule 2 of the Paja rules provides that a Paja review can be brought in terms of Rule 53 or Rule 6.
Yes, absolutely.
None of the authorities that you cite in your heads of argument deal with the import of Rule 2 of the Paja rules.
Yes, absolutely. Because there's something controversial about.
Can this court then rely exclusively on those authorities that don't deal with Rule 2 of the Paja rules? And this is in fact a Paja review.
Well, Justice Theron, because there is nothing controversial in Rule 2. All what Rule 2 does it confirms already what the Jockey Club has already said. So you're not bound to Rule 53. You can even do it in terms of Rule 6. And what is the answer to that? Because the record is there for the benefit of the applicant. The applicant chooses the mode of how he or she wants the matter to be adjudicated. And if the applicant chooses Rule 6, the applicant does not even require condonation from the court, because that is the election that the applicant. So I don't think that there's anything controversial in Rule 2, which requires this court to pronounce on. But of course, if the court wants to clarify it, then so be it.
The difficulty, Mr. Makari, is if we have regard to Rule 2, it allows, as you say, the applicant an election. How do we read that and interpret that rule with the statement by the High Court in its judgment at paragraph 54? The applicant's remedy lies in an action procedure, and the election to proceed on motion was fatally misconceived from inception.
What is the question there? I mean, you want me to confirm that the High Court is wrong there?
What is your comment on that, Mr. Makari?
Okay, what I'm saying is that if you look at what the court say in that paragraph, it says it in the context of it having refused to refer the matter to oral evidence. And it says that the only option available to you is action. Because it has already refused then referring the matter to oral evidence. I don't understand the court to be saying that you can't refer them, I mean, you can't institute review proceedings under Rule 53 and then ask for referral to oral evidence. I don't understand the High Court to be saying that. Unless if then I'm misinterpreting it, then unless if you are reading it differently, but that's not how I read the judgment.
Doesn't Rule 2 say it can be brought in terms of Rule 53 or Rule 6?
Yes, of course. Yeah.
Yes, but not by way of an action.
No, I mean, Justice Theron, our jurisprudence become part of our law. I mean, they were referred in our heads of arguments to the Nelson Mandela Bay judgment, which specifically refers to action. And then also then the Hockey Club judgment. Once the court developed jurisprudence, and the rules are not above the court is the arbiter, is the final arbiter, and the court is the one that set precedents, not the rules. The rules are not there. I mean, then the court is not there for the rules. The rules are there for the court, not vice versa.
Thank you, Mr. Makari. Thank you, Acting Chief Justice.
Thank you, Justice.
Mr. Makari, through you, Acting Chief Justice, may I put a question to Mr. Makari?
Thank you, Justice Matopo.
Mr. Makari, if we look at section...
I'm sorry, I didn't realize that I had muted myself. Just before you do so, Justice Matopo, just two questions, Mr. Makari. Isn't the position that when a court in motion proceedings decides to refuse referring a matter to oral evidence, that does not relieve it of its obligation to adjudicate the dispute? In other words, you can't dismiss the application and your reason for dismissing it is that there are disputes of fact. Isn't the position that you have to examine disputes of fact? Sometimes the disputes of fact are such that it is the respondents who have put up disingenuous disputes, bad denials, in which case then you use the applicant's version. But sometimes the respondents have not put up bad denials and disingenuous disputes. They are genuine disputes and they are material. And then the applicant must make an election as to whether to ask for referral to oral evidence or not. But if the court refuses to refer the matter to oral evidence, it must still adjudicate the dispute. But in that event, the dispute is adjudicated on the basis of the version of the respondents, insofar as there's a dispute between its version and the applicant's version.
Yes, no, you're absolutely correct, Justice. ACJ, that is how in practice then things work, and I think that by law. So the court must adjudicate the dispute. But in this matter, there was no dispute that there are material disputes. So the court must adjudicate dispute, not common cause facts. So here, it was a common cause fact that there are material dispute of fact. So basically in practice at the moment, as counsel you should be knowing, the moment the court say to you, there are material disputes of fact here. How are you going to go around this? Do you accept that there are material disputes of fact? The moment you say yes, you must just know that you have lost the case if the court is going to refuse your application of referral to oral evidence. That's how it is. Because what is it that the court must now still adjudicate on the merits when there is a concession that there are material disputes of fact? And once there are material disputes of fact, then the case must be decided in favor of the respondent based on the respondent's version. So in this matter, it was common cause that there are material disputes of fact. But you are correct, ACJ, that if there was no concession that the material dispute of fact which can be resolved, then one would have expected the High Court to now analyze the papers, the evidence, and then decide that I don't agree with the applicant's counsel that there are no material dispute of fact because of them mentioning this and this and this and that, and say that Plascon events is against you, and therefore the application is dismissed. But in this case, then there was a concession. So all what was left was, that's why I'm saying that if one reads the judgment, the only thing which remained was whether then the court should grant referral to oral evidence or not. That was the only thing that remained there.
The second question I wanted to ask is this. Is it appropriate, would it be appropriate for, or would it have been appropriate for the High Court to refer the disputes of fact to oral evidence or maybe let me put it this question. Is the position that it's crucial that the findings of the commission should be set aside before any disputes of facts can be resolved? Because as long as those findings have not been set aside, and they include credibility findings against the first applicant, then it would not be appropriate for the court to find differently on the same issues. In other words, is it crucial that those findings be set aside first, or that decision be set aside first, because otherwise they stand? Or not?
Well, I didn't think about it, but I'll say that just one.
I'll tell you what. I'm just thinking that we have a situation where the commission listened to evidence and made certain credibility findings. Now, the disputes of fact that maybe might go to oral evidence, maybe arising out of these proceedings or not. If those findings have been set aside of the commission, maybe then there's no problem. But if those findings still stand, can another forum seek to resolve the same disputes.
Yeah, no, I understand. So that could be what triggered the High Court in paragraph 54. I mean, paragraph paragraph 52 to zoom into those credibility findings made against the first applicant in the Kata Commission. And we were aware that the applicant also want to nullify the findings and recommendations of the Kata Commission. But you seem to be correct that those findings, given the nature of the commission, its statutory power, it is created in terms of statute, so it performs a public function. So those findings will have to be upset first without being second-guessed by another forum. But in this case, we know that the applicant is one of the things that it wants to upset by nullifying them. Although, of course, there are obstacles there, but because the matter proceeded in a particular manner in the High Court, that was not even ventilated. But if I may give just one example of some of the problems with regard to setting aside that report, it is a 2017 report, and then the application is brought a year later. So then you have issues of condonation, which you must bring. There is no condonation, all those sort of things. So it's a non-starter, but because the court didn't even go there. But I agree with you then, I mean, that it seems as if, given the nature of the commission and its statutory nature, that those findings will still remain. Well, I think also then Odikral then may be applicable. That as long as that decision is there, then it remains, it exists in fact and law.
Thank you. I think there was a colleague who still wanted to ask a question.
ACG, I'm covered.
Are you covered? Okay, all right. Okay, it looks like there are no further questions from colleagues. I think, Mr. Mukari, we are done. I can proceed to hear. We can proceed to hear Mr. Egan.
Thanks very much, ACJ. Then it was a quite interesting debate and interesting issue.
Yes, yes. No, thank you. Thank you. Thank you. Thank you. Mr. Egan.
Chief Justice and members of the court, if I may, before I go any further, I don't know what the practice is with lunch in the court or things like that, but my nerves require me to request after this long sitting just a short moment to run for a comfort break.
Yes.
Stay for the duration of my my address.
Yes. Okay. I'll tell you what I maybe, to the extent that you might wish to have a comfort break, maybe we could have about 5 minutes. But we normally try and finish if we can before we take the lunch break. That's not a rigid rule. I'm trying to look at my colleagues' faces to see if there is an indication one or another. So I'm thinking that if you need comfort break, maybe we can take a 5 minutes break and then come back and try and finish. Does that look fine? Sound fine, colleagues? Okay, all right. But before we go, Mr. Egan, I had said I would also give you 45 minutes, but the issues have been dealt with quite at length, including with Mr. Mukari, who is for some of the respondents. I've no doubt that some of the issues you wanted to canvass, he has raised. So when we come back, I would like to give you less time than 45 minutes. So that you can then just focus on that which either you don't agree with Mr. Mukhari on, or that which you want to emphasize. Is that fine?
Yeah, Acting Chief Justice, thank you.
Okay. Let's take a 5 minutes break, comfort break then. It's 5 past now. Or should I say 10 minutes? It's 5 minutes to little, or 5 minutes should be fine. Okay, let's say 5 minutes. We'll be back at 10 past.
Thank you.
We adjourn.
Acting Chief Justice and Justices of the Constitutional Court or Council are online.
Are we all back? Yeah, it looks like we are all back. Mr. Egan, I was thinking that maybe I should give you 30 minutes. Are you aggrieved or you are fine with that?
Acting Chief Justice, I'm fine with that. To the extent that the questions for me, I anticipate that will be determinative of the amount of time that I take.
Yes.
The heads of argument we filed, I think, were quite comprehensive. I think the issues have been ventilated to a degree.
Yes.
And my contribution may be limited in the result.
Yes, no, that's fine. But you can accept that even after the hearing, we still go back to the written submissions and go through them and read them again. So you may go ahead. The first 10 minutes, we will not interrupt you. But after that, then we will.
Thank you, Acting Chief.
Acting Chief Justice, I'm sorry to interrupt you. I do believe that counsel for the applicant has not been able to reconnect.
Oh, is that so?
Yeah.
Zonate, can you hear me?
Acting Chief Justice, yes, I can.
Are you trying to assist them, or is the challenge on their side?
The challenge is on their side. I'm actually on the phone with advocate at the moment.
Okay.
Oh.
Acting Chief Justice, I have just admitted counsel for the applicant. Let's see if she's able to connect with us.
Okay. Oh, there she is. Okay. Are you there, counsel for the applicant?
Yes, I'm here. I'm on.
Okay.
Chief Justice, thank you.
Thank you very much. You may begin, Mr. Egan.
Thank you, Acting Chief Justice and members of the court. If I may begin by addressing the fifth respondent's application for condemnation in the matter, which is proposed by the applicants. The condemnation requirement for condemnation arose, and it's explained in the application by there's no other way to put it, but a mistake on the part of the fifth respondent's legal team in the interpretation of the applicable rules, and being under the misapprehension that the time period provided in Rule 11 of 15 days to file an answering affidavit in an application was applicable in the circumstances with the application having been launched on notice of motion supported by affidavit. Of course, we are since wiser to the fact that in practice, litigants in this court do adopt the notice of motion and founding affidavit, which is not expressly provided for in Rule 19, but nonetheless is applied. It's further explained that the misapprehension also arose from references within that notice of motion to Rule 11. And that then resulted in the answering affidavit being filed on day 15, as opposed to day 10 as required by Rule 19. It was my submission of bona fide and non-prejudicial error because the affidavit, although filed 5 days late, was filed 7 months prior to the hearing. It enabled the applicant filed a replying affidavit, which may to a certain degree have perpetuated the misunderstanding because Rule 19 doesn't provide for the filing of replying affidavits. That's a Rule 11 procedure. So to the extent that the two rules have cross-pollinated themselves in the fifth respondent's legal team's head, gave rise to this error. It was overlooked. The objection was overlooked in the replying affidavit, which was filed. And the fifth respondent's legal team only became wise to the error of their ways when the written submissions were to be filed. And immediately, within a day of becoming aware, explained to the court that they jumped into action and filed an application for condonation. Now, the prejudice, to the extent that there is any, which the applicant's counsel raises in argument in opposition to the condonation, comes in my submission from the approach adopted of regarding less than perfect procedural steps as pro non scripto. The court will have noted in the quota quo in the High Court, this happened as well. And the argument is advanced that where the applicants disregarded the answering affidavits filed because they took issue with the commissioning. And therefore, the argument is that they only became aware of the disputes of fact at the date of the hearing when those affidavits were admitted. Now, similarly, in the condonation application, there was a notice to oppose, which was called upon in the notice of motion in terms of Rule 11, ironically. So the applicant knew that this was opposed. An answering affidavit is filed, and they ignored that answering affidavit if they did at their own peril, I submit. So I submit to the court that there has been an explanation provided. The length of the delay in filing the answering affidavit, not launching the application, was a mere 5 days. It was non-prejudicial to the parties, and I submit did not affect the administration of justice at all. So in my submission, I submit that there's a proper case made out for condonation, and I would ask that the court grant it accordingly. If there are any questions about that, I'll happily address them after my 10 minutes. If I can then briefly touch on the Rule 53 point, which was argued quite extensively already, Acting Chief Justice. And I think Justice Unterholter raised the other law question. And it struck me in response that if one has regard to Section 7 of PAJA, Section 7 of PAJA refers to proceedings and therefore doesn't limit the applicants in their approach to the court to simply a motion proceeding. And that would be, I submit, an example of another law, so to speak. Then in terms of the discretion issue, I'd like to begin by making the following submission to the court, that when the judge president in the High Court, when it became common cause between counsel, at the very least, that there was a material dispute of fact, which meant that the High Court couldn't resolve the disputes on the papers. The High Court exercised its discretion under Rule 65G. And Uniform Rule 65G reads that where an application cannot properly be decided on affidavit, the court may dismiss the application or make such order as it deems meet, with a view to ensuring a just and expeditious decision. Now, it's my submission briefly on this point that the court was exercising a discretion. The heads of argument deal with that discretion extensively. But the dismissal of the application, the wording of the rule per se, doesn't require more. It doesn't require the court to have definitively found against the applicants in the circumstances. But within the broader exercise of exercise.
Mr. Egan, I'm sorry to interrupt you. Acting Chief Justice, counsel for the applicant has again lost connection.
I think what we will do is we are going to proceed, and we will give her an opportunity to file further written submissions after reading the transcript in regard to any points that would have been made while she was not connected. So in reply, she can reply to what she had, but she can read the transcript later on and file further written submissions in regard to points that may have been made in her absence. I think that will help. Otherwise, we won't finish if we keep on stopping. I think she will accept that. Okay, all right. Proceed, Mr. Egan.
Thank you, Acting Chief Justice. If I may then, and the last point I want to address on the Rule 53, and it was an interesting debate which ensued with, I think, Justice Majid was whether about the prejudice and the lack of the benefit afforded to a party by Rule 53. And it is so that I too was unable to find any authority which is based on an action for review proceedings. Now, as Mr. Makari pointed out, I submit correctly, that doesn't mean it cannot be so. And it will probably be so that at some stage in the future, courts will be required to determine the applicability of the record provisions of Rule 53 to action proceedings, and whether the request for that record under Rule 53, which is wider ordinarily than a discovery process, is going to be applicable. There are several rules in the Uniform Rules which apply to all manner of proceeding, be it action or motion, and the possibility that Rule 53 record provision will be applied in an action proceeding, I submit, is not ruled out. While Helen Suzman, the court, speaks to the importance of that benefit, the importance of the record, it doesn't limit the ability of a litigant on action to seek provision of the record. And within the broader context of Rule 53 and the obvious benefit that that provides, it's my submission that a court will have great difficulty refusing a litigant that benefit if the litigant elected to proceed with review proceedings on action. It's as yet obviously undecided, but there is nothing that rules it out. So my submission is that the benefit is not lost. In the present case, it's also been ventilated extensively that the benefit was there, and the opportunity thereafter arose to apply at any stage for a referral to oral evidence, which was just not taken up. And if one considers the fact, the reasoning why it wasn't taken up, as advanced by the applicants in the application in this court, they tell this court that they didn't apply because on their interpretation, which I submit is wrong, the disputes of fact didn't arise until the court accepted the answering affidavits. Now that falls foul of so much, justices, insofar as can a party who sees a less than perfect affidavit raising...
I interrupt you to just say that the 10 minutes is up. You may proceed, but you may find that colleagues have questions. So go ahead.
Excellent, Justice. Just lastly on that point is the applicants were certainly aware when they received those affidavits. They say in their answering affidavit to our application for condonation that condonation is as between the court and the litigant. And it's trite, there's ample authority that a court can condone less than perfect commissioning of an affidavit. So the applicants would have known, or should have known, that the affidavits raising those disputes of fact, whether they get condoned ultimately or not, is not a matter for them, but they can't ignore them. And yet they did. And that's why they were caught bringing an application at the last minute when this arose. That's their version. If I can take the court to page 108 of the record, that's the amended notice of motion. And I want to go there in the context, justices, of the legal points raised. Well, my client's not really a party to that dispute of the Section 30 dispute and the Section 26 dispute. There are 2 points that I want to make with regard to this. If one has regard to this amended notice of motion, it's my submission that it's not immediately apparent where the issue raised now on the a Section 30 issue falls within this relief. We accept that Section 30 requires the Premier to receive the report and do A, B, and C with it. That we can accept that. That's what the section says. But when it comes to the argument that he didn't do that, and the next step of saying, well, we're going to review that failure to take that required step, where does the relief lie that the applicants seek in that regard, in regard to that failure? And I submit that the court will struggle to find that. If we look at the relief briefly that's asked for, the first relief is that the decision of the Premier taken on 1 June 2018 not to recognize the identification of the first applicant as an acting traditional leader be reviewed, set aside, and or corrected. Now that's a section 12 argument, and that thereon there is a dispute of fact as to the genealogy, as to the royal lineage of the first applicant, etc. The second relief, that it's declared that the first applicant qualifies to assume the position of acting traditional leader. Well, that's got nothing to do with section 30. 3, that the first respondent be compelled to recognize the first applicant as acting traditional leader. Again, it's a section 12 issue. It's got nothing to do with section 30. Then 1.4, that's that the recommendations of the commission be declared null and void. I'll return to that in due course. Then 5, that the decision of the Premier to recognize the fifth respondent as acting traditional leader be reviewed, set aside, and nullified. And then costs. So of the substantive relief sought in the amended notice of motion, Justices, only one of them relates to these legal issues that we find in the papers and the heads now. There's no actual relief sought in relation to section 30. So the court in the High Court would have, considering, even if the High Court had done extensive analysis on the papers in relation to that issue, there's no relief sought. The only relief on the legal point sought is the section 26A, that it be declared null and void. The court will have regard, I believe, to the second supplementary affidavit filed by the applicants in the High Court, where they bemoan at great length the apparent bias and malice of the commission in the conduct of the proceedings. None of that is before you today. Before you today, it appears that the applicants proceed on the basis of saying that the commission outran its term, and because of that, everything it's done is invalidated. That, in a nutshell, is what I believe the argument to be on the section 26 point. So 26 4B, I think. 4B, yes, Justices. That appears to be the argument. Now, insofar as that relief stands to be considered or stood to be considered as a legal point by the High Court, this court should look at the record and ascertain in relation to the onus whether the applicant discharged that onus. What evidence did the applicant put before the court which would satisfy the court that the onus is discharged and that the commission's time had lapsed without extension? We've heard in this court that there is a government gazette which extended the period of the commission. Now, in the High Court, what the applicant, the first applicant, tells you is that he was advised that the period had ended. There's no evidence before this court, and it actually, sadly, ought to have been relatively easy evidence because it's a matter of gazettes. But there's no evidence before the High Court that the commission commenced on date A and it definitively ended on date B. And it's my submission that insofar as discharging their onus, the applicants ought to have presented that evidence. Can't be left to anyone else to make out their case. In this court, Justices, we confronted with a document which I believe is provided for the first time. I was unable to find anywhere else, which is attached as Annexure D2 to the founding affidavit. And this talks to the establishment of the subcommittee. The commission established, as you'll know, under the Act, 2009 Act, is a national commission, which then appoints subcommittees. And the subcommittee in this case, for example, was only appointed on the 14th of May, 2012. That's the subcommittee that's...
Counsel for the applicant, it looks like that noise comes from your side. I may be mistaken, but yeah, okay, please proceed, Mr. Egan.
Acting Chief Justice. So what this document tells us is that the committee of the commission to investigate claims in the Limpopo province was established on the 14th of May, 2012. So it wasn't established simultaneously or contemporaneously with the National Commission. It was a separate entity established in 2012. And there it does say that its lifespan will run to 31 December 2015. Now, it's as far as onus goes in the quota quo, it's important for the applicant to have made that decision.
Excuse me, Mr. Egan. Sorry to interrupt you.
Yes, Justice.
To what extent, if any, does the Section 30 point have a bearing on this case? I'm asking this in line of the debate that my sister had with Mr. Mukari, whether the Khatla Commission made a decision or a recommendation or whatever, or whether it declined. But when I read paragraph 213, it says they declined to make whether it's a decision or it's a recommendation, you would probably want to interpret it differently. Assuming this is the position, to whose benefit, if any, does this failure, if I were to put it that way, redound to? Does it advantage the first applicant or the fifth applicant, or disadvantage all of them, or both?
Justice Matopo, my interpretation would be that it has no relevance. It has no relevance. The first applicant took a dispute to the commission. He raised the dispute. He went there making a claim. The claim was declined. Until such time, there was obviously a status quo which existed throughout this whole period. And until such time as the commission would have made, or a court makes a decision that changes the status quo, it would remain. So in terms of the argument of whether the Premier submitted the report to the House or not, and the effect that it would, the question which must be asked, I guess, is whether the submission, that pure act, would have made a difference. Now, the failure to do that, may be a problem, and it would. I forget the case in this court. It's not Lunga. I think it was Lunga, where the procedural failure was the issue there. Well, it was on the basis of that incorrect application or the non-application of the provisions of the Act, which became the problem for the Premier there. But insofar as this matter goes and the relief goes here, it's my submission that the inverse is true and that it doesn't make any difference because it doesn't serve to change any status quo. And that is what I believe Advocate Mukari was getting at when he argued that there was no implementation to happen. If one goes to the record and goes to the letters written at page 101, for example, that's a letter dated the 1st of June 2018. Now, that simply says, please be informed that your claim has been finalized by the Commission and you've been duly notified of the outcome. Copy of the letter is attached for reference. And then over the page 102, the Premier in paragraph 3 says, I, in my capacity as Premier, hereby inform you that your claim is declined. So what the Premier does here, he doesn't take any decisions. He's merely informing the applicants of the outcome, and that the outcome is a decline. It's a no. You've approached the Commission seeking to alter the status quo by making a claim. I'm informing you that that's declined. The status quo persists, and there's nothing to be implemented. And it's occurring to me as I'm saying this, the question would be whether the House of Traditional Leaders would be able to overturn the decision or the recommendations of the commission, or overrule the recommendations of the commission. That case is not made anywhere. And insofar as the relevance of this Section 30 argument goes, that sort of power, I submit, would be relevant, a relevant consideration, but it's not put before, it's not put in the High Court, and it's not put here. So, long story short, Justice Matopo, the answer to your question would be no in my submission. It wouldn't make a difference. And irrespective of that, there was no relief sought. If I can then, related to that, but also related to the prayer, which is actually there, regarding Section 26A, for seeking a declaration that the Commission's work be null and void. There's a delay here of some 355 days before this application was instituted. So to review the work of the Commission and say, well, the Commission failed to fulfill its mandate timeously, and therefore its work must be set aside and declared null and void. There's no explanation in the papers. Well, there is, but it's to the contrary, as to why the applicants took such an inordinate amount of time to launch these proceedings. The application was brought in terms of PAJA. Section 7 is peremptory in this regard as to the 180 days. There was no application for condonation. There was not even a request from the bar for condonation. I was there. There was not even a request from the bar. It was left hanging. Now, as a jurisdictional fact, to bring your PAJA application, one must surely address that it's brought within the time periods, and if not, that you've applied for condonation. But that doesn't, the court won't find that anyway. So if I can return to this amended notice of motion then, the Section 30 dispute that we are arguing on the strength of, well, it appears to be argued for argument's sake, because there's no relief sought in that regard at all. And the relevance of that Rule 30 in that time period, which is particularly gone after in this court, is not explained to the court. So there's no basis in my submission for the court to take the Section 30 argument any further as a legal point. Secondly, insofar as the Section 26 point goes, the traditional leadership point, there I rely again on the question of onus in the High Court. And there's been much back and forth and speculation.
Mr. Egan, I'm sorry to interrupt you. Is an attempt not made to explain the delay at page 414 onwards, paragraph C?
Justice Theron, while I get there, my recollection of the delay was it was occasioned by the attempt by the applicant to install himself as
Your submission is that no application for condonation was made. This is dealt with at page 414, paragraph C.
I see that, Justice Theron. I apologize that the statement then was too harsh on my side. I can rephrase the statement and say it is dealt with, but it's dealt with not by any sort of formal relief. That's number one. The applicant by this stage, and if it's 414, that means it's probably the second supplementary affidavit where this is eventually dealt with. There's no relief sought either in the first unamended notice of motion or the amended notice of motion, of the late filing. The condonation naturally has to be accompanied by good reason. The delay is minimal. The they calculate they don't actually calculate the total number of time on their version. My calculation, for argument purposes, was 355 days, but there's a number of months that are calculated there. And the submission that's made to you in paragraph C is that the delay is minimal. Now, my submission, I'm not convinced that that's sufficient for the purposes of making out a case for condemnation, especially when the case for condemnation comes in a second supplementary affidavit without any consideration for introducing relief to that effect. So it is addressed, but my submission is it's not properly addressed, and it's not addressed to the degree to which I submit this court should accept it. The circumstances are not set out in that paragraph. It's just said it's minimal. Now, the applicant's own approach to a minimal delay is exhibited in the 5-day delay in the condemnation application. They took us quite to task about that 5-day delay. Yet here expect the court to accept that delay in excess of 100 days must be accepted merely by the allegation that it is minimal. I submit that that's not sufficient, Justices. Justices, just on the point that a few points raised from the applicant's argument, if I may. Pardon, if you could, just give me a moment.
Okay.
Justices, if I can then return to, let's deal further with the Amendment Act point at this stage. I've highlighted the impact of the delay, which is unanswered. And further needs to be addressed is whether there's a case made out that the commission's work be declared null and void. Well, I've already dealt with that in the sense that of saying that that was the onus that was drawn by the applicants in the quota quo, was to demonstrate that if they were relying on the fact that the commission's period had expired, demonstrate to the court when it started and when it ended. That's, I submit, the minimum that a party should do, but they failed to do that. Thus, so far as those two legal points go as a basis for considering whether the quota quo erred in the exercise of its discretion, I submit that there's both those legal points on the papers in the quota quo didn't have prospects of success. And that may have informed the judge president's finding to that effect in his judgment, that there were no prospects of success. The disputes regarding the genealogy are dealt with by the judge president in his judgment. What happens is, and I appeared in the High Court, was there was a concession made that there are material disputes of fact. The judge president correctly reflects that, and it's the first time today in argument that we hear that there was no such concession made. Once that concession is made, he says to the parties, go away and prepare heads of argument on what the appropriate outcome should be. Should I dismiss it or refer it to oral evidence? That election that he asked for further evidence, further argument on, comes in my submission from Rule 6.5G, which says either dismiss it or make such order as deems meet. And that's the exercise of discretion. And when the parties make those submissions, he finds that in the broader exercise of that discretion, there's no basis to refer it to oral evidence, and he dismisses it. As I submit, Rule 6.5G entitles him in the exercise of his discretion to do. There's no suggestion in the...
I want to mention, Mr. Egan, that we have exhausted 30 minutes, but you may try and wrap up, depending also on whether there are questions from colleagues.
Thank you, Acting Chief Justice. My point, I'm nearly done with this point, so then I'll be done.
Yeah, yes.
The exercise of that discretion I beg your pardon. Acting Chief Justice, if you have regard to the judgment, the judge president, insofar as the genealogy disputes go, which go to the root of all matters in this dispute, as Justice Collipin pointed out, those disputes are addressed by the judge president. He considers those disputes. If one has regard to the 4 out of the 5 prayers sought in the amended notice of motion, they all stem from factual disputes which go to this dispute over the genealogy. And so on that basis, it's my submission that the judge president exercised his discretion properly. There's no suggestion in the application before you that he exercised it improperly in the extent to which the authority suggested is required for a court of appeal to interfere in that regard.
Mr. Egan.
Mr. Egan, can you tell us, when you say there was no exercise of a discretion which should alert us to difficulties in the way it was exercised, I'm not certain that I entirely follow your argument, because you say this application was dismissed without any determination on the merits. Is that correct? It was just exercising the Rule 6 competent to dismiss in the face of disputes.
Yes, Justice.
So do you also accept the proposition that in the context of a review application, where all the procedures are used to procure the record and exchange affidavits, that a court should be very cautious before it dismisses for disputes of fact rather than refer the matter to evidence? And what seems to have actuated the judge president is that he took the view that it might be problematic for the applicant because of what the commission had decided on credibility questions. I mean, that may well be a disability that attaches to the applicant if the matter was to be referred to evidence, but it hardly is the basis upon which you would not refer so as to finally resolve the disputes, which he found were so great as not to permit him to decide the matter on its merits. Isn't there a tension here in the manner in which that discretion is exercised?
Justice Ontolta, let me perhaps answer it this way, is that the parties, this wasn't something that occurred in a flash, so to speak. The parties were given opportunity of about a month to present argument to the judge president on the exercise of that discretion, to do whatever they felt necessary. I understand the tension argument that you raised to say that we've come this far, if I understand it correctly, shouldn't we just go a little further? And when we consider the exercise of that discretion ex post facto and with the benefit of hindsight now, we've got to consider that it's easy to say at this stage that perhaps one should be cautious. And I don't think there's any suggestion here that the judge president didn't consider this thoroughly, wasn't cautious in his approach. There's nothing to that. If I raise the fact that, and he says it in the judgment, so I'm not giving you evidence per se, he stopped the proceedings and said, prepare heads.
No, I understand that, but what this in effect condemns the applicant to, if the applicant wishes to proceed, is to start a trial action all over again.
In the circumstances of this matter, the applicant, that would be the applicant's next step. I don't want to adopt the judgment's remedy terminology, but the proper course here now would be to consider the matter. And I can't recall which of the justices pointed it out. that at the outset, one considers where you stand and what the strength of your evidence is before you go into either action or application proceedings.
No, but I think we've by now established that in review proceedings, it is very, very undesirable generally to initiate by trial action, which is precisely why there is no evidence that anyone has ever tried to do it, even though it's technically possible. So the natural course of action is to bring your proceedings under Rule 53. If there is a dispute of fact, what's the rationale for forcing an applicant who wishes to proceed, because that's apparently what they wanted to do, to start all over again?
Justice Untolta, perhaps the question can be answered in this way, is that a referral to oral evidence is not quite, but it's not quite as simple as it seems as a process. There's obviously the distinction in 6.5G, the court's got a discretion. Either I dismiss this application or I make an order as deems meet. Now, one of those is everyone is banding about the referral to oral evidence. Now, 6.5G, I believe, when it talks to oral evidence specifically, talks to oral evidence on specific issues. Now, someone's got to raise those issues, and someone's got to put that before the court and say, we propose that this, and there's the matter in my heads of argument, I believe it's called Joe Eyre, which expressly says that it shouldn't be left to the presiding judge to figure out what the disputes are and what should be referred and in what terms.
That may well be, but a judge would the judge president could simply have said, I think a referral to evidence is appropriate. Please formulate an amalgamated engineering order defining the issues that are to go to evidence.
And the exercise of his discretion to go the other way has to be improper, has to have been improperly exercised.
Well, just explain to me, in the face of an applicant that wishes to press on, in what circumstances is it ever desirable to force the parties to go and start from scratch? I'm trying to imagine what those circumstances are.
It's from a hypothetical perspective. The circumstances of the matter as a whole are going to have to be considered when deciding, well, do we say go and start on the whole? In this case, the judge president says that his consideration of the evidence before him suggests to him that the application, insofar as the substantive relief goes, it was a non-starter. Now, I've pointed you to the actual relief, and that 4 out of the 5 prayers relate to questions of fact and genealogy and so forth. And he deals with that quite extensively and gets to the point where he expresses the view, obita, as part of the exercise of his discretion, to say, I don't think there's any prospects here. So perhaps in that case, and now onto the hypothetical point, perhaps in that case, I say to the litigants, if I dismiss you now, it is no res judicative to you, come back in an action. There is a judgment of this court. It may also be longer. I beg the court's pardon for not knowing where one of the, I believe, minority judgments spoke initially up front to the difficulty in documenting issues relating to traditional leadership and so forth. We're often dealing with things where paper is not a great way to go as so far as proving claims and so forth. And one might hypothetically find that going forward, as memories fade and documents that may have existed disappear, that actions in these disputes, these review disputes particularly, are going to become more prevalent, because when we don't have documents or the documents are insufficient as they were here, what do we have? And
that's a vastly impractical view. Trial actions take years and years to resolve, and most reviews are resolved in motion proceedings relatively quickly. But in any event, thank you. I've heard your submissions. Thank you, Acting Chief Justice.
Thank you. Mr. Egan, did you still have issues to address, or is there a colleague who wishes to ask a question?
With your leave, Acting Chief Justice, I would like to.
Yes, Justice Theron.
Thank you, Acting Chief Justice. I just note that we've at counsel for the applicant has again lost connection. She's about to rejoin though.
Yes. Okay.
Regarding the concession that was made, Mr. Egan, I can refer you to paragraph 31 of the judgment, please, page 435. Line 4. It says, counsel conceded to the existence of material disputes of fact. Did counsel for the applicant concede that all the issues could not be decided on the papers due to disputes of fact?
Be careful how I put this, but the judge president put it to the parties that he couldn't decide the application because there were material disputes of fact. There was no distinction drawn between the nature of the particular prayers. That I can tell you.
Let's look at the first sentence in paragraph 31 as to what was put to the parties. It says, at the hearing of this matter on 15 October 2020 and during oral submission, I raised a question to counsel for the applicants concerning the numerous disputes of facts raised by the respondents, the substance of which cannot be decided on the papers. Now, it's not clear as I read that sentence which issues those disputes of fact go to and which issues were precluded or the judge president felt precluded determination because of the disputes of fact. So I repeat my question, Mr. Egan. Did counsel for the applicant concede that all the issues that were before the High Court could not be decided on the papers because of material disputes of fact? Or did counsel concede that there were material disputes of fact? Full stop.
No. Justice Turun, I'm sorry, I'm not sure if your question was a positive or negative, but counsel conceded that the existence of material disputes of fact precluded the judge president from deciding the application on the papers. There was no.
I'm not sure that appears from paragraph 31. See, the judge president says that there are disputes of fact which cannot be decided on the papers. Does the judge president say that all the issues that are raised for determination cannot be decided on the papers?
That's not what he's saying in paragraph 31. Justice Turun.
So that could not have been the concession that was made by applicants' counsel, because that was not what was put to applicants' counsel.
Justice Turun, what I was trying to, I think maybe we're at cross purposes, maybe I understand now, is what I'd initially tried to explain to you was what actually happened versus what's conveyed in the judgment. Now, what's conveyed in the judgment.
Unfortunately, Mr. Egan, you're not in a position to give evidence from the bar.
And
So
I was careful.
we are confined to what is in the judgment before us.
Justice Turun, insofar as that goes, then I can't take it further than the wording that the judge president used. He uses numerous disputes of fact, for example. So I'm not going to try and pull a square peg through a round hole as far as that wording that the judgment uses, which is that numerous disputes arose. But what I've shown you in the amended notice of motion was how far the disputes of fact, which on actual genealogy facts, which we've stopped talking about hours ago, how influential that was on the actual relief sought, and to the point in my submission where it was all determining.
Mr. Egan, the last point I would like to raise with you, you would have heard Mr. Makari say or concede that on the papers in the High Court, there were no disputes of fact regarding the fact that the Premier did not refer the Gatle Commission's recommendations to the Provincial House, and there was no disputes of fact that the Commission had not issued its recommendations within the 5-year period. Do you agree with that? Or are you able to point us to the record where these disputes of fact appear from the record in the High Court and that they were raised by the respondents?
No, I'm not going to differ from Advocate Makari's concession.
Thank you, Mr. Egan. Thank you, Acting Chief Justice.
Thank you. We are at 2 o'clock. Are there any colleagues who still have questions? No, I don't see any indication. Mr. Egan, do you want to wrap up? Are you done?
Acting Chief Justice, I'm happy with the submissions as in my heads of argument.
Yes, you stand by them.
Yes, Acting Chief Justice.
Yes. No, thank you very much, Mr. Egan. Thank you. I will now invite counsel for the applicant to reply, and I will give her 10 minutes. Counsel for the applicant.
Thank you, Acting Chief Justice. I only have
there is a noise from your background.
Sorry.
There is an echo from your side. Counsel?
Yes. Firstly, yes. Firstly, I would like to apologize. I'm interchanging my gadgets. I'm experiencing a problem with my network, so I'm trying to interchange my gadgets. I'm having a problem with network, but I will proceed, Acting Chief Justice.
Okay, before you proceed, there were times when we lost you. You were not connected, and I said, let's proceed.
Yes, I'm proceeding.
If there is something that you did not hear because it was the address continued in your absence, please indicate, and we can give you an opportunity to file written submissions to deal with those points that were dealt with in your absence, let's say within the next 10 days or so. So you must just indicate if you would like that opportunity or whether you are covered. You can read the transcript afterwards.
Yes,
maybe.
Acting Chief Justice.
Yes, maybe I should say
yes.
You must arrange to read the transcript afterwards and see if there are points that were dealt with in your absence. And if there are points, we will give you about 10 days within which to file written submissions dealing with those points. Is that fine with you? Written submissions dealing with those points. Is that fine with you?
Thank you very much, Chief Justice. That will be fine. Thank you very much.
Okay, all right. Okay, all right.
Okay, I'll proceed with my submission. I'll proceed with my submission.
Yes,
okay,
there is an echo.
I'll proceed with my submission.
There is echo. There is echo from your side.
I think council has 2 devices on, as I can see on the screen.
Well, if the technical problem proceeds, I don't know if it's sorted out now. If it proceeds, I wonder whether everybody would be happy that we ask you to just put in your reply in written submissions within the 10 days.
Chief Justice, if I may assist, please.
Yes, sure. Justice Theron.
Advocate Morato, please can you turn off one of your gadgets as you refer to them?
Can you turn off one of your gadgets as you refer to them?
Yes, I have done that, but I'm still struggling with network. That is why I've been interchanging them.
The difficulty is that we are seeing two of you, Council. And we hear
let
me switch.
Okay. I don't know whether this would be acceptable to everybody, but it would be acceptable to me. Should we just ask council to put in her reply in writing within 10 days?
We have no objection to that, ACJ.
You would have no objection to that.
Yes.
Counsel for the applicant, would you be fine with that?
That will be fine. In fact, I have not heard most of the presentation from both the respondents.
Oh, is that so?
Yes,
okay.
I've been struggling.
Colleagues, let me hear what my colleagues say. Particularly, maybe if you have not heard most, then maybe that's the way to go, to allow you to get the transcript and read everything, and then file the written submissions as your reply to the oral argument. Colleagues, how do you feel about that?
We do agree.
Is that fine?
I'll support that as well. Thank you.
Yes, yes. Okay, I think my colleagues are fine with that. If that's fine, then I suggest that we stop here. And that's what you will do. And then once we have received your written submissions, which will take the place of your reply, then we'll take the matter from there. The court will then consider the matter.
As the court pleases, and thank you, Acting Chief Justice.
Yes. Okay, all right. I think, therefore, let us end the proceedings here on the understanding that that's the arrangement. And then once we have received the written submissions, we will consider the matter. In the meantime, then the court will reserve judgment and the court adjourns.
As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.